ಏನ್ ಚೇಚ್ ಕಾಣಿಸ್ತಿಲ್ಲ, ಕೇಳಿಸ್ತಾನೆ ಇಲ್ಲಲ್ಲಮ್ಮ. ಕೋರ್ಟ್ ಆಫೀಸರ್, ಕೋರ್ಟ್ ಆಫೀಸರ್, ಕೇಳಿಸ್ತಾನೆ ಇಲ್ಲ.
ಹೇಳಿ ಸರ್.
ಕೋರ್ಟ್ ಆಫೀಸರ್
ಸರ್ ಮೇಡಮ್ ಕೇಳಿಸ್ತಿದೆ.
ಹಾ, ಇಲ್ಲಿ ಲಿಸ್ಟ್ ಅಡ್ಜರ್ನ್ಮೆಂಟ್ಗೆ ನಾವು ಬರೀ ಮೂವ್ ಮಾಡ್ಬೇಕಾ ಅಥವಾ ಲಿಸ್ಟ್ ಕರಿತೀರಾ?
ಪೇಜ್ ವೈಸ್ ಅಡ್ಜರ್ನ್ಮೆಂಟ್.
ಪೇಜ್ ವೈಸ್ ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಅಲ್ವಾ?
ಓನ್ಲಿ IA ಆರ್ಡರ್ಸ್, ಅಡ್ಮಿಷನ್ ಅಂಡ್ ಹಿಯರಿಂಗ್ ಅಷ್ಟೇನೆ. ಆರ್ಡರ್ಸ್ ಅಂಡ್ ಡಿಸ್ಮಿಸಲ್ ಆ ತರ ಕ್ಯಾಪ್ಷನ್ ಅಲ್ಲಿ ಇದ್ರೆ ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಕರೆಯಲ್ಲ.
ಓಕೆ ಓಕೆ. ನಮ್ದು ಯಾವ್ದ್ರಲ್ಲಿ ಇದೆಯಮ್ಮ? ಸೀರಿಯಲ್ ನಂಬರ್ 7 ಯಾವ್ದ್ರಲ್ಲಿದೆ ನೋಡಿ. ಮೇಡಮ್, 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 ಮೇಡಮ್,
ಹೇಳಿ. ಅದು IA ಆರ್ಡರ್ಸ್ ಅಲ್ಲಿ ಮೊಹಮ್ಮದ್ ಸಲೀಂ ಅಂತ ಇದೆಯಲ್ಲ, ಅದು ಅಡ್ವೊಕೇಟ್.
ಹೌದಾ? ಅಲ್ಲ, ಸೀರಿಯಲ್ ನಂಬರ್ 7 ನೋಡಿ. WP ನಂಬರ್ 20,809. 20,807.
ಅದು IA ಆರ್ಡರ್ ಇದೆ. ಸಬ್ಮಿಷನ್ ಮಾಡಿ ಆಮೇಲೆ ಪೇಜ್ ವೈಸ್ ಕರೆದಾಗ.
ಪೇಜ್ ವೈಸ್ ಕರೆದಾಗ ಮಾಡ್ತೀನಿ. ಸೂರಜ್ಗೆ ಹೇಳು, ಸೂರಜ್ಗೆ ಫೋನ್ ಮಾಡಿ ಹೇಳು. ಅಲ್ಲಿ ಎದುರುಗಡೆ Yes.
Memo for posting. Memo for posting.
Mofa?
MFA, my lord, the 2022, the claimant, appellant is sustained grievous injuries and 37% of the disability, my lord. He has not received any compensation till
per
today.
your-
my lord.
Lordship, yesterday I spoken, it was about spoken to, it was not.
Yes.
This is for non-prosecution, my lord.
Huh?
So they can dismiss, my lord, file application for restoration.
We'll see, we'll see.
No,
It
my lord, matter listed and then, warrant and.
it will be issued.
Earlier, this honorable court.
Court is giving you opportunity, you are not.
Same matter was granted, same, my lord. So the non-compliant was dismissed, my lord. Can you take up on Monday?
We'll see when a time permits, yes.
Yesterday it was, no, it did spoken to,
Huh?
it's not been listed here.
File is not available, they are subject.
Lord, this is a fresh matter which had been listed on Saturday. By wrong print of the name of an advocate, my lord, the matter came to be adjourned to 16/9. In fact, the costly shows that someone's name of the advocate has been printed. It is not they who hold the brief. So it may be taken up tomorrow.
We'll see, yes. Call the list.
Page was adjournment. Number 1, page number 3, serial number 6 to 8.
My lord, serial number 6.
Serial number 7.
My lord, serial number 6. Respondent, senior throat infection. My lord. Next week.
My lord, serial number 7. Look at the 6.
Six.
Look, take out this file, 6.
6, ma'am.
Give the order sheet. Should have submitted that. Also for the respondent is unwell. Let's this matter on 11th of November. Yes, 7. My lord, serial number 7. The counsel on record, my lord, is suddenly fell ill today. She has been taken to the hospital. Wherefore, your lordship may have it next week, my lord.
Serial number 7 by appeal for petitioner. We are ready to address.
If somebody is not well,
Then we have
this is matter on 18th. At the request of non-counsel, the respondent. Yes.
Page number 4, serial number 9 to 17. Page number 5, 18 to 26.
serial number 18, my lord. Senior counsel is not well. Have it on next week.
I'm respondent in this matter.
Moreover, the respondent number 2 is attain majority, file necessary application.
You are for who moved the memo? Who moved the memo?
I moved the memo in the last occasion, my lord. In the last occasion, they took the adjournments. A date was given to them.
We will
This
see.
time maybe
We will see when the matter comes. Every day we will not list the matters like this and adjourn them. Yes.
Page number 6, serial number 27 to 32. Page number 7,
Huh?
Serial number 30.
Hmm.
Kindly request to sign
30.
We appear for whom?
petition.
You must be having interim order. Have you informed the other side about your taking adjournment? Wait.
Page number 7, serial number 33, 34.
Appearing, serial number 34, your lordship, appearing for respondent, I seek for a week's time.
And for the petition.
Can be adjourned.
I leave it.
You have an interim order?
Yes, sir. In one of
Interim
the
order
matters,
earlier granted is extended. List these matters on 9th of October.
List number 2, page wise adjournment, list number 2, page number 2, serial number 7, page number 3, 8 to 11.
Serial number 11, my lord.
8, my lord. Serial number 8. And for the petitioner, my lord, senior is not keeping well. Kindly have next week.
Who appears the respondent?
Ravi Shankar.
Wait. have you informed them?
Yes, my lord. Kindly have it.
It is submitted at the request of the, it is, learned counsel, the petitioner seeks time. It is submitted that it is already informed to the learned counsel for the respondent. List this matter on 23rd of October.
My lords, kindly have it on 11th of
It can't happen as per your
Page
dates.
number,
Yes.
Serial number 11, my lord. Kindly refer to mediation, my lord. Serial
Which
number
one?
11. 11, my lord.
Learned counsel sub.
Petition.
Where is the counsel for the
Adish
respondent?
Bandariti,
Sorry.
In his presence, we will do it.
All.
Yes.
Lords, I apologize. Serial number 34 in the list one, my lords. 9th of October was given. May I request an earlier date because in my second petition, their visitation rights are not being granted. That's the only reason.
Because the problem is, the other court, every day 35 matters, 40 matters, earlier roster are given. So if I grant a short date, matters will go to 100, 120. It's difficult for the court to even, I can have a list of 200, but I should complete it end of the day. That's the only
I was only
difficulty.
expressing.
That's what I'm requesting the advocates, whenever the matters are listed, don't ask for time. Because once they come, once they are out of the list, they will not come again.
Counsel for the respondent had called and informed that there's a medical emergency. That's why I had consented to it. That's why I am.
Which is that?
Serial number 34.
34 and
This is
34 one.
Point
bill
one
number
is what?
34. List the matter on 23rd.
23rd, obliged.
Yes.
23rd of this.
list number, page number 4, serial number 20 to 17, list 2, page number 4. Page number 5, serial number 29, 18, 19.
Serial number 19, Your Lordship. I pray for a week time, Your Lordship.
Why?
Your Honor, Your Lordship, I have a ligament here, Your Lordship. I was not able to come to court and collect documents, Your Lordship. So I seek for 1 week time.
This is matter on 8th of December.
There's an interim order, Your Lordship. I pray for extinction.
8th of December, interim order earlier granted is extended. Yes.
Much obliged, Your Lordship.
List number 3, page number 5, serial number 13 to 13, 14. Page number 6.
13.
Senior is not feeling well.
Balu Mahendra.
Have you informed the other side?
Girish
Yes.
B. Baldare.
Informed?
Yes, my lord.
It's submitted that the learned counsel seeks for time, and it is already informed to the learned counsel for the respondent. This is matter on 17th of December. Yes.
Page number 6, serial number 15 to 18. Page number 7, 19 to 22.
Serial number 22, my lord. A week's accommodation. Yesterday only I am engaged by for appellant. I have informed the other side, Pradeep also. Legal question is there.
It's the matter on 25th of September.
26. Okay.
Page number 8, serial number 23 to 28. Page
25, my lord. That's for appellants in the case, my lord. Senior is not well, my lord. Can you
Why all
add-
seniors are not well?
Suman Tel Bharadwaj.
Same representation by everyone. Have you informed the other side? Same. This also listed in the month of December. Yes.
Page number 9, serial number 29 to 31.
Serial number 29.
My
my
lord,
lord.
31.
For R2.
31 minutes.
Kindly a week's time may be granted. my lord. Senior is
Why?
not. Senior is not well. my lord. So,
Ravi
Serial number
Shankar
31.
Geeta.
Geeta Raj.
Yes, ma'am.
At the request of learned counsel for the insurance company. List this matter. Is it yesterday's matter?
No, my lord.
List this matter on 2nd December.
Serial number
Achha.
30.
My lord, serial number 31, my lord.
Serial number 30. Kindly week's time, Your Honor.
Why?
Ravi Shankar CR.
Senior is personal inconvenience. He went out of station.
Natwaju T.
Why? Are you from his office?
But yes, ma'am.
Then why can't you argue? Even for this also senior is
Not an
required
inspection on
for
that.
MFAs.
And not an inspection.
Very unfortunate that so all
Kindly
these
one-
MFA matters are also sought time by the advocates. What is the fate of the clients who are waiting for the compensation? When the court is ready to do, advocates are not ready. Everybody says, no, court also can't even reject senior unwell, senior unwell, senior unwell. If senior unwell, juniors are there to argue and the court will take care of it.
My lord,
Yes.
serial number 31.
Yes.
Serial number 31. One more matter is connected, my lord, 3538 of 23, which was not in this list, my lord. That has
It's
to be
okay.
heard along with.
It is okay. It will come. We will decide it. We'll decide these three and that later.
It is a common judgment. It is a common judgment, my lord.
Doesn't
The
matter.
insurance
Doesn't
company has
matter.
taken the. My lord,
Doesn't matter.
insurance company has taken.
That doesn't matter. When the other matter comes, we will do that also. We'll take it up in the afternoon itself. That matter also I'll call for. Yes.
Yeah,
Cell number
3538 of 23.
Yes. Please come.
Page
Take that number MFA.
3538.
3538 of 23.
Call for that. Yes. Next.
22 na sir.
Yes.
Page number 10, cell number 32 to 35.
32, my lord, serial number 32, my lord. I am for the appellant in this case, my lord. I have already informed the other side, my lord, week's time may be granted. Some
What is the
inconvenience.
reason for
My
adjournment?
lord, claim petition was dismissed, my lord.
Then-
Entire records has been, evidence and all exhibits are in Kannada, my lord. It is a difficult to argue, my lord.
Because court, even on no matter, I'm asking for any.
Entire evidence is Kannada, my lord.
That
Because
advocate, you will read and tell the court. Court will understand.
there is some inconvenience. That's why I'm not.
List this matter on 17th of December at the request of non-counsel the appellate. Call the list.
Number 14, matter settled not before the family court. That's why it is
Cell number 14 in list 1, sir.
This one.
List 1.
Take that.
Ah.
A memo is filed stating that the MC number 5413 of 2022 and criminal miscellaneous number 809 of 2022 pending between the parties is settled before the mediation center. Hence, nothing survives consideration in this petition. Accordingly, the memo is taken on record and dismissed as withdrawn. Yes.
Great.
List number 1, parted matter, cell number 1. KV Narasimhan for petitioner. VB
Lord, I appear
Sidramaya.
for the petitioner. Lord, in the cause list showing there's a memo of dismissal filed by petitioner, my lord. It is not filed by me. Lord, with respect to merits, my lord. Lord, petitioner is the father, my lord. Lord, the present petition is filed against the order of the family court, which has directed me, my lord, to pay an amount of rupees, 5,000 rupees to respondent minor child. My lord, my only submission is I have taken a contention that the respondent, my lord, is not a child of the petitioner. My lord, with respect to that, I take up a contention, my lord, I file an MC petition against the wife, stating that you have deserted me from 5/6/2019. Then, my lord, respondent files objections. This, my lord, this petition under 125 came to be filed by respondent, stating that she was born on 3/6/2020. Then, my lord, I've also filed an application before the trial court and Order 26 Rule 9 seeking for a DNA test. So, my lord, in all the court, my lord, from the filing of my MC petition till the present petition, my lord, I have vehemently objected to the fact that respondent is the legitimate child of born to petitioner respondent wife. My lord, and even that application, my lord, seeking for DNA test is pending before the trial court. So, my lord, my submission is, my lord, that until that,
No, it is other way around.
my lord,
Till that is decided, he should be granted maintenance.
Lord, I'll state for 2 minutes. Lord, I filed this petition on 2021, my lord. In the year 2021, MC petition under section 13. In that petition, my lord, I specifically take a contention that wife has deserted me on 5/6/2019. Then, my lord, wife comes up with a story that this respondent was born on 3/6/2020. Then, my lord, to the application, even to the application filed by this respondent, my lords may take my statement of objection for a moment. Statement of objection is at page 15.
Did she say that she left on that day?
My lord, she is taking up the contention that 12/10/2019 is the date when she left.
When?
12/10/2019. That is her contention. But,
So,
my lord,
at this stage, it is a premature stage to decide all that, and that cannot be decided in a miscellaneous. You have to
But in fact,
take steps. If once the DNA test is done, once you're able to prove that you're not the biological father, things will flow.
But in fact, if my
one
lords
more,
may-
I will clarify with respect to this aspect. Respondent is ready for DNA test. She has no objection for DNA test.
In fact, my lord, if my lords,
That you should tell before the court in the
No,
MC.
we have already told before the court.
And the court will order for that.
Here also, it
Lords-
may be recorded from my side also, we have no objection for the DNA test.
my lord, one another submission, my lord, if my lords may take the, I send a legal notice, my lord, initially in the year 2019. To that reply, my lord,
Whatever it is
Please.
in this petition, we cannot decide now. Please come.
my lord, with respect to that amendment application, I filed an amendment application that may be allowed.
What is the amendment?
My lord, by oversight,
Hmm.
lords may take the amendment application for a moment. It's filed on 21/3/2025.
Hmm.
My lord, in the cause title of respondent,
Hmm.
by oversight, my lord, it is referred as daughter of TV Vikas, that is petitioner. My lord, all along we have been objecting to the fact that.
No, how can you change the cause title?
My lord, in the writ
Whatever,
petition,
no, whatever is a cause title below the court, it has to continue like that.
my lord, my only apprehension.
No, that will not be taken as if you are accepting it. When a petition is filed and you're selling an order, the cost list, cost title will be as it is. You can't change the cost title.
Well, my only apprehension is that may be
I
used
will
against.
record,
me.
I will record
Please,
that and,
please.
this is a docket order. IN number 1 of 25 is filed.
One more submission, my lord. I have filed a memo requesting this honorable court to enhance the maintenance amount by furnishing the court fee receipt.
Huh?
I have filed a memo
Hmm.
by furnishing the receipt for the school expenses, requesting to enhance the
Like
maintenance.
that. IN number 1 of 25 is filed seeking the amendment of the cost title. In the cost title before the trial court, it is shown that the minor is the daughter of the petitioner herein, as he is denying the relationship. Now he wants to amend the cost title. Such an application for amendment cannot be allowed, and the cost title has to be as it is mentioned before the trial court. Hence, IN number 1 of 25 is dismissed.
My lord, an observation may be made that same may not be used against me.
No, I said you cannot. I said that you want to amend the cost title, but it is not permissible. I said. But that's a subtle. How can you go? Whatever you feel like, you can't amend the cost title. You are questioning an order that is passed. Whatever is there before the court, it has to be there. Otherwise, it will not be numbered also.
Only difficulty is
There
I
won't be.
felt-
It is not a difficulty at all. Agreed with the orders passed. I number 2 in criminal miscellaneous number 94 of 2022, whereby the family court had granted maintenance of an amount of rupees 5,000 to the child. The father is before this court. Then counsel appearing for the petitioner submits that he has filed the MC seeking divorce on the ground of cruelty. It is his case that the wife had left the husband on
5/6/2019,
5/6/2019, and the date of birth of the child is
3/6/2020.
3/6/2020, which on the face of it clear that the petitioner is not the father or the biological father of the child, and the petitioner cannot, the petition need not pay and as such he has no obligation to pay the maintenance. The court had failed to consider this aspect in those circumstances, and in fact he has filed an application with the court to conduct the DNA test, and the same is pending consideration. Till that application is considered, the petitioner, the respondent is not entitled for maintenance. Next part. When counsel appearing for the respondent wife submits that the wife is ready for a DNA test. Even before the trial court also, it is submitted that the DNA test may be conducted. Further, they have filed a memo seeking enhancement of seeking educational expenses of the child that may be considered. He submits that unless and until the said application is decided, the petitioner cannot seek any relief on the ground that the child is not he is not the biological father of the child. Next, for having heard the counsels on either side, there is a material on record. With regard to the paternity of the child, considering the disputed questions of fact, the court cannot decide in a summary proceedings under 125 CRPC. Admittedly, the MC is pending before the family court where an application is already filed. In those circumstances, the court in 125 CRPC proceedings cannot do a roving inquiry with regard to the paternity of the child. Further, the memo that is filed without filing a writ petition, with seeking enhancement of the compensation, the court cannot consider the memo that is filed before this court in the writ petition filed by the husband. In that view of the matter, the compensation of 5,000 that is awarded by the court. This court is not inclined to interfere. Accordingly, the writ petition is dismissed. Yes, next.
For order serial number 2. Serial number 2.
For the respondent in this case, my lord, before getting into the merits of the matter, on 23/7/2025, your lordships had given an oral order saying if the petitioners do not comply with the office objections within 1 week without referring to the court, this petition shall stand dismissed. Whereas till date they have not done so. On light of it,
only office objection raised today is on the statement of objections filed with the respondent to my rejoinder. There is no objection raised on my rejoinder.
on 23/7, my lords, if your lordship may permit.
To sign each page of objection, that's your objections, not his.
But all the office objections.
So now I'll allow his writ petition.
My lord, then in that case, I have another submission to make. My lord,
He will make in that case. First, he is a petitioner.
okay.
Yes.
Lord, I'm not. This matter is moved by the respondent. Matter suddenly came.
Whoever
before
is
the
moved,
court.
I'll hear the matter.
Lord,
Yes.
Any day
Argue.
next week.
Huh?
My senior will argue any day in the week after next week. In the meantime, let them comply with the office
Interim
objections.
order, I will not extend the interim order.
My lord, there
At
is-
the request of land council.
My lord, interim order kindly be
I will
extended.
not extend.
Before the MC
It
case is posted for
it is
judgment.
Item number 2 in the list and you ask for adjournment.
That is regarding the office
At the
objections.
request of land council for the petitioner, list this matter on December 2nd.
Lord, interim order may kindly be extended because the MC matter is posted for judgment. At that time,
The MC matter is posted for judgment. What is the
then the
purpose
court
of this
will,
petition?
then the court will proceed with the matter and this
No, no, it is
petition will
posted.
become
What is-
infructuous.
Give that, what is the impugned order?
Lord, this was only for the maintenance which they had filed the petition.
Why should we keep it pending now? Why should we keep, when the matter is posted
Since
for
last-
judgment, 1 minute.
Apologize.
When the matter is posted for judgment, what remains now to be decided?
Lord, in the meantime, their application for striking off my defense is allowed, and therefore the family court proceeded with the
Give the
matter
impugned order,
and
give that
record
order.
that.
Where is impugned order, page number?
Page number 79.
When is this order passed? This
7/7/2021.
order is passed on
7/7/2021.
7/7?
2021.
Hmm.
In that application, they have sought for interim maintenance of rupees 20,000.
Hmm.
8,000
The
is
court
granted by
granted
that.
8,000. What is your salary?
Lord, I am agriculturalist, owing only 2.5 acres in the agricultural land. But the respondent is a software engineer working in a private company in Bangalore.
Is it
And
so?
she's
My lord, she is a software engineer.
What is her income?
My lord, as per my instructions, she
20.
was working on a temporary basis. So it would be around 50 to 55,000 as per my instructions, my lord. Lord, I have another submission to make. This petition was filed for a stay on the maintenance which was granted. So I would like to press to this honorable court that we will not go forward with the pressing of interim maintenance, whereas the proceedings in the MC case shall go on because the respondent is waiting
We
for.
will decide this. It is a very simple application. Court had granted 8,000. According to him, he is an agriculturist. You are working and your salary is 50,000. Why should the court grant 8,000 maintenance to you?
But this is the present salary, and as per their contention that they are holding only 2.35 acres, that is false.
Let us take it even if he's holding 10 acres also. When you are educated, you are employed, getting 50,000, why do you want maintenance?
But in that case, then I will not press for that maintenance claim in the lower court. So I would.
First of all, I'll discuss this petition. I will allow their application by certificate disorder.
Yes, my lord. A short date can be given. Then will because the main reason being, my lord, there is another 3 petitions connected with the same matter, because the agricultural land, what they're saying, is an ancestral property. So the respondent's own sister is also fighting for a divorce case, and she has filed for maintenance. And whatever the petitioner is claiming, so the respondent's younger sister is married to the petitioner's younger brother. So citing a stay in this particular matter, they are coming and filing an application saying there is a stay in the matter, which is a connected matter. So kindly adjourn the matter. So this is going on since last 2 years. So if in that case, we will not press for maintenance by the respondents in this case. So let the stay get vacated and the matter be disposed of by early hearing, so that we can continue with our other cases, my lord. This is my humble submission.
Please come. Agreed with the order passed in IA number. What is the IA number? IA number 1 in MC number 336 of 2020, whereby the court had granted 8,000 per month as maintenance to the wife. The husband is before this court. The wife had filed the petition seeking maintenance of an amount of rupees 20,000 per month. It is a case that the husband is having property worth rupees 2 crores, which includes 15 acres of irrigation land and a house, as well as good source of income from the land. The husband has filed his objections and stated that the IA is not maintainable. It is his case that she is employed and earning handsome salary, and she is capable of maintaining herself. It is his case that he is working as agricultural labor and he owns 1 acre of land, 1 acre of wetland and 2.5 acres of dry land. He is capable of maintaining the family out of the income derived by him, and the said land is ancestral and joint family property. The tribunal, the family court, in that only the wife had forgave her expenses that she needs 60,000 per month, and it is more than her salary. The court had considered the contention of both the parties and observed that the wife is an educated and a working woman. She has come up with this application seeking maintenance, and the court has to consider the case from both sides, wherein the wife is not completely dependent on the respondent. However, in order to show that she has low income and she is unable to maintain herself, and there are no documents available on record, and only the oral statement stated to be the supportive evidence for the alleged act of the respondents. Hence, without holding a mini trial, looking at the facts of the case, the court is of the view that the wife has stated that she is unable to maintain herself, and she has to pay for her education loans, house rent, and other expenses, including the litigation expenses, and accordingly court has granted an amount of rupees 8,000 ex parallel, and counsel appearing for the petitioner husband submits that when the wife is working and the husband is an agriculturist, the court ought not to have granted maintenance of an amount of rupees 8,000. There is nothing on record to show what is the income that is derived from the agriculture land, and it is stated that he is eking out his livelihood by doing the working as a daily laborer. It is submitted that the wife is not entitled for any maintenance when she herself is capable of earning 50,000 per month. When counsel appearing for the respondent submits that the respondent wife submits that the petitioner husband had suppressed the fact about the properties that he is holding, and the court, considering all this, had rightly granted the maintenance, and there are no grounds to interfere. Under the guise of the interim orders passed by this court, they are not proceeding with the matter. Hence, there shall be a direction to the family court.
Lord, I have another submission to make. There are two orders under challenge in this writ petition. Another order is their application under Order 6, Rule 16 for striking off my defense is allowed. That impugned order
On
is
what ground?
that we are not paying the maintenance as per the order of this, as per the interim order.
This is the whole difficulty, filing two writ petitions, questioning two IAs in one writ petition.
Lord, that application is considered without considering my application for summoning the documents. I have filed an application for summoning of documents from the company of.
Whatever it is, when there is an order, we'll do one thing. I'll allow that, because in the light of this order being set aside, that also will be dismissed.
That application may be-
However, I'll impose costs in that, because you have not complied with the order of the court.
Let there be a direction to reconsider that application filed by them, because before passing orders on their application for striking of defense, I had filed an application for summoning of documents from the respondent working company. That application is not considered. No order is passed on that
Understanding what the court is saying, whatever is your application, when an order is passed for maintenance and maintenance is granted, it is your duty to pay the maintenance. Until you came before this court, you kept quiet. So there is a deliberate violation of the orders of the court. What I do is, when I am setting aside this order, there is no maintenance in the eye of law now. So I'll set aside this order, and as far as other IA is concerned, I will allow that also. But however, you will pay costs to the wife. Yes. The present writ petition is, where is the other IA?
Yes, ma'am.
Page number.
Now, before the trial court, there are two applications pending.
I said, where is the impugned order in this? You said
Impugned
there
order
are
is
two
page
IAs, sir.
111.
Yes, that's what I'm asking. That's not the impugned order, 101. It is a statement of objection. At least are you clear?
Annexure P at page 111.
111. You should have informed the court first before I start dictating the order. Initially, that the petition has come before this court, questioning an order in IA number so and so, and also an order dated. What is the order dated?
2/8/2022.
2/8/2022, whereby the court has allowed an application filed under 151 CPC by the wife to strike off the defense of the husband. No, come to this. What was I dictating? his contention. Hence, there shall be a direction to the family court to dispose of the matter. It is also submitted by the legal counsel that when there is an order of maintenance by the court, and when the husband has failed to comply with the said order, the court had rightly passed an order striking of the defense, and there is nothing to interfere with the order. In his contentions with regard to that application, he submitted that the court had allowed an application filed by the wife under 151 and the defense to strike off the defense. It is submitted that when already an application is filed by the petitioner husband seeking certain interrogatories, certain documents, and without considering that application, this order came to be passed, which is not justified, and the same is liable to be set aside. Next paragraph. Having heard the counsels on either side, there is a material on record. First, coming to the aspect of maintenance, the wife is earning. She is a software engineer, earning an amount of rupees 50,000 per month. According to her, husband is having a lot of ancestral properties, and he is deriving a lot of income out of that. There is no evidence on record to show what is the income of the husband from the said properties. When the wife has failed to prove what is the income of the husband, and when it is a case of the husband that he is a daily wage worker, and when the wife is earning 50,000, she cannot seek maintenance from the wife, and without any basis, a court cannot grant maintenance to the wife. In the considered opinion of the court, the order of maintenance granted by the court, by the order impugned in IN number 1, whereby maintenance of 80,000 is granted, is contrary to the facts and law. Accordingly, the IN number, the order passed in IN number 1 in MC number 336 of 2020 is set aside. Next, coming to the application that is filed under section 151 of the CPC to strike off the defense of the husband as he failed to.
Lord, my request is let that application be reconsidered, my lord, because without
Yes,
without
filed,
reconsidering,
yes,
I will be having no grounds to proceed with the
Yes,
matter.
filed, yes. Why it should be reconsidered?
Because my application for summoning of document is not considered.
What for
The
for
family court
summoning
was
of the documents?
from the respondent company, from
When
the company where the
when
respondent
her
is working.
maintenance petition itself is dismissed by this court, what will you do by summoning the documents?
My lord, already with regard to that order of striking of my defense, that application,
You're not
because
understanding.
I'll be not having any grounds for to proceed with the MC matter. Because my
Setting aside that order, what is your difficulty?
please.
What did you write? 151 is concerned. When the court was perfectly right in allowing the application, whatever are the reasons, when an order is passed by the court, it's a duty of the party to comply with the order. The reasons that are stated by the argument of the learned counsel for the petitioner husband that that he has already filed another application and the same is pending consideration. In view of the same, the court ought not to have filed this passed this order under 151 CPC, has no legs to stand. The court was perfectly right in passing the said order, but in the facts and circumstances where this court is setting aside the order passed on the maintenance that now at this point of time that order passed under 151 CPC needs to be set aside. However, considering the conduct of the husband who has failed to comply with the orders of the court, that application is allowed on the order under section 151 CPC is set aside on the condition that the petitioner shall pay an amount of rupees 20,000 to the wife within 2 weeks from the date of receipt of the copy of the order. Accordingly, court is passing the following order.
My lord, sorry to interrupt. Just if your lordships can include one more point there, saying just because this order is set aside, so that shall not prevent her from exercising her right over claiming and partition in her maternal side ancestral property, because the petitioner is none other than the maternal uncle of the
Please
respondent.
understand, the court need not give such a clarification. Your rights under the Indian Succession Act will be governed independently.
Apologies, my lord, because they might bring this to just delay the matter. So that's the reason I had to make this submission. If your lordships can.
In the submissions, it is submitted that the parties are related, and if this order is set aside, and it would come in the way of the wife in claiming inheritance in the ancestral properties. Next, in that IA
Maternal side ancestral.
maternal side and ancestral property, in the discussion with regard to that maintenance case, the submission that this order would come in the way of of the wife in claiming inheritance in the maternal side ancestral properties. This court finds no force in the argument, as this has nothing to do with her. If at all she has a right of succession in the said property. Next, come to the last. Accordingly, this court is passing the following order. The order passed in I number 1 in so and so is set aside. The order dated that 151, the order passed under section 151 dated so and so is set aside on the condition that the 20,000. This is pending before which court? This case.
Seventh Additional Senior Civil Judge, Bangalore Rural District, my lords.
It is posted for judgment.
I do not have much information on that part.
It was posted for judgment when this petition was filed.
This petition, as this is it is submitted that the petition is posted for judgment by December 15th. The MC shall be disposed of by the family court.
Much problem.
Then number 3, Zamir Pasha, for petitioner Dilraj Jude Rohis Sequera.
My lords, in this case, only one submission. Counsel for respondent Pratima ma'am's name is still coming, my lords. That needs to be deleted. I think a fresh NOC is filed by somebody else.
Yes, who has filed? No name is here.
In second matter, my lord, still Pratima ma'am's name is coming. That needs to be deleted, my lord.
No, but nobody has filed wakalat.
I think
You
so.
filed wakalat.
Who?
Dilraj Rohit Sequera.
In all the matters.
In one matter.
In one
Yes,
Please, Lord, husband's petition.
there
First,
are 3 petitions.
Lord, the first petition, WP 24314, Lord, is arising out of the MC proceeding for dissolution of marriage. Lord,
No, what is IA?
IA for expeditious disposal of the proceedings, because since 2019.
This is expeditious disposal.
Yes.
Then WP 19557.
Then Lord, WP 19557 is arising out of the maintenance proceeding.
How much is granted?
Lord, 60,000.
Is granted.
Yes.
How much is sought?
Lord, exorbitant, it's, I'll just point out, Lord, from the.
Then what is the next writ petition?
Then it is another writ petition is under the GNWC proceedings for the custody.
What is IA?
IA for Lord, Lord, the relief of visiting right was granted, but not complied by the respondent wife, not allowing me to meet the children.
Your Vasanta Vikas is
Yes.
the husband.
Husband.
So let's see the first writ petition. Which year is this MC?
MCM, Lord, it was initially filed in 2019 in Sivakasi. Lord, the petitioner and respondent, Lord, the matrimonial home was in Sivakasi.
No, pending before which court?
Now, Lord, pursuantly, Lord, she approached the Supreme Court, and the cases, Lord, under MC proceeding and GNW, which were filed by the husband before Sivakasi, transferred to Bangalore.
Which court I said?
4th additional family court.
So everything has to start afresh whenever you have filed.
That's going on.
So there
The
can't be any
difficulty now,
direction
Lord.
now. This is an MC of 2022. Please come. The present petition is filed. WP 24314 is filed, seeking the following relief. Learned counsel for the petitioner, husband submits that all the proceedings have started in the year 2019 and the pending consultation till now. As such, there may be a direction to the family court to dispose of the matter. As there is a specific direction to the family courts to give priority to the matters which are filed in 2019. This court cannot pass an order to dispose of the matter of 2022. In that view of the matter, this court do not find any reasons to.
Lord, because she is very often changing the counsel. Since 2 years, there is no cross-examination. And there are serious allegations of infidelity, Lord.
Hence this court do not find any reasons. Accordingly dismissed. Come, give the next 19557. Yes. Please come to the order.
Lord, impugn order, page 12.
Are entitled for 20,000 each. Who are the petitioner?
Lord, the wife and
No
children.
wife and?
Wife and children.
Wife and 2 children.
Yes.
What is the age of the children?
Lord, the son is now at present in class 10th. Daughter is in 7th.
In 7th. What is the income of the husband?
Income is shown as 60,000 in my affidavit of assets and liabilities.
60,000. And court granted 60,000.
Court granted entire 60,000.
Let's see the discussion.
Impugn order, Lord.
Here in the present case, respondent himself had.
I will read that paragraph, Lord.
Yes.
Here in the present case, respondent himself had stated that he is director of so and so. On the other hand, the petitioner had also produced some photographs to make out the standard of living of the respondent when he was with the petitioners. Further, he had also produced photographs with regard to the company of the respondent that their companies are all over India and they're sufficient companies, and even there are Vadivelu buses. Hence, taking into consideration the source
Both of you have not filed your statement of assets and liabilities?
I have filed, Lord, as per the format, Lord, of Rajnish and Neha. But the respondent, Lord, the format given, please see the affidavit of the respondent.
Has he filed his statement of assets and liabilities?
My lord, senior is not in station, my lord. I'm appealing for the proxy counsel. I need to seek instruction.
Please see page 45 for a moment, Lord. Page 45. 45.
Heard the counsel for the petition in part. At the request of learned counsel, the respondent lists this matter the day after tomorrow as part heard.
Lord, there is an interim order.
Interim order earlier granted is extended.
Lord, may I request your lordships to, Lord, reconsider my request for the expeditious disposal of the MC case, Lord. Because, Lord, since 2 years it is not
There are
cross-examined.
so many matters which are pending from 16. What to do? Yes. That is disposed of. That is dismissed, not dismissed. Next 2 matters part heard. Thereafter. No. In 3.1 and 3.2 also show the name of Dilraj, whatever it, look at it.
May I make one request,
Delete
Lord?
the name of both the councils.
Lord, one request at least. Lordships may kindly accommodate me this much. Lord, direct the respondent not to, Lord, drag on the cross-examination. At least, Lord, let there be a direction to the respondent to conduct cross-examination at least. If not, expeditiously disposal of entire
The
proceeding.
issue is the court will not take up your matter now because they'll give priority. We have directed the family courts not to take up any trial of any other matters except 19 matters.
Right,
Only IAS will be considered. They will not hear the no cross-examination now.
I'm Lord, concede to that, Lord. But since 2 years, she keeps
But
on
anyhow,
changing
you
the
will not be
counsels.
successful, however you take, you ask, so just leave it there. Yes, part heard, day after tomorrow.
Great.
Next.
Cell number 4, Anjan Kumar BN, for petitioner.
Even in the last date of hearing, she was present, Swami. The court was
Madam,
insisted
ನಮ್ಗೆ
her to
amount
engage the counsel.
Lawyer engage ಮಾಡ್ಕೊಳಕ್ಕೆ.
The respondent party is present before the court and seeks time to engage the advocate.
Even in the last date of hearing.
ಮೇಡಮ್ ನನಗೆ ಲಾಯರ್ ಎಂಗೇಜ್ ಮಾಡ್ಕೊಳ್ಳೋಕೆ ಅಮೌಂಟ್ ಪ್ರಾಬ್ಲಮ್ ಇದೆ.
Legal Services Authority. It is submitted that she has difficulty, party in person is present before the court and submits that there is a difficulty to engage the counsel. The she shall approach the Legal Services Authority, and the Legal Services Authority shall appoint an advocate, and immediately after the wakalat is filed by the advocate, list this matter.
Date may be fixed.
It will immediately come. Ask her to go today.
Number 5,
Ask her to go today.
madam. Serial number 5, Lata NS, for petitioner.
Post after service of notice. Look at it, if interim order is there, extend in 5.
Serial number 6 and 7 adjourned. Serial number 8, preliminary hearing 8, Karumbaya TA.
Last date of hearing, your lordship had asked me about the salary of the husband. My lord, we don't have any pay slips. We are not sure about the number, my lord, but he works in a mutton shop.
You appear for the husband.
Husband, my lord, this is
So why
husband.
you're not sure? He should tell you.
We asked him, my lord. but-
Then we will dismiss your writ petition. Because when you know, when your husband, your client is not giving you instructions, what you can do?
I'm aware.
That's the whole thing. Tell him, I'll pass over. Tell him that if he doesn't tell what is his income, I'm going to dismiss this petition. Pass over.
Yes.
Serial number 9,
I appear for petitioner. In
Karjunaya.
this case, I am challenging the order passed by the trial court IA number 1. I have referred this writ petition, my lordship. It is at page 13.
Page?
It is at page 13. As may kindly see, the impugned order passed is directed to pay 10,000 per month maintenance to child. Earlier in MC, page 15 it is stated, so it is already ordered for interim maintenance in MC.
1 minute.
Page
Now
15.
the court has ordered 10,000 to the child. And to the wife, how much you are paying?
We are already paying 5,000 in MC 68 of 2000, which page 15, the order itself says, my lord.
That's what I'm saying, to the wife.
I am not to for child,
Earlier 5,000, now 10,000 it is.
to the child. And here he is drawing more than 2 lakh salary. She is a professor in engineering college.
You're
And-
seeking an enhancement. You're for the husband.
And he has filed as many as 6 cases against me. Now the petitioner is suffering from TB and stroke.
First of all, I'm not able to understand you are appearing for the wife or husband.
5,000 to child.
Which case?
Serial number 9,
Serial number 9.
Mallikarjunaya.
Yes.
Mallikarjuna is
Mallikarjuna P. Wali is
Petitioner name is also Mallikarjunaya.
husband.
Mallikarjunaya Mali.
Srimati Nandini is the
Respondent.
You are
Respondent.
appearing for the husband.
Husband is paying.
Sir, ma'am is
Are you arguing which case? Which is the case number?
Which is 25325.
whether you are appearing on behalf of the
On
husband,
behalf petitioner.
petitioner husband or wife.
Petitioner, it is husband. On behalf husband, Mallikarjuna Mali, I am appearing.
That's what I am also asking from the last 2 minutes. And you are arguing and as if like you are
That's
appearing
it.
for the wife.
That's in that case, trial court, I am respondent. Here I am petitioner.
No, court has granted 10,000. What is the salary of the husband?
What is the
Salary of the husband.
husband is,
Salary of the husband.
no, he is no job at all. He is now lost his job also. He is not having any income. I stated in my affidavit also. He is entirely dependent on his brother and mother now. And he's, I clearly stated in my, therefore in the earlier MC, the trial court has passed an order to pay 5,000 to the child.
Please come to the order, let's see.
Yes, Lordship, may kindly see. Kindly see page 15, my Lordship. Page 15. The trial court order itself says earlier order for interim maintenance in MC 68 of 2016, rupees 5,000 per month. This is I am paying. Now she has filed, that MC was filed by husband. In that case,
5,000 has been ordered by the trial court. Now she has, in the MC filed by the wife, order on IA number 1, the trial court passed an order 10,000 per month. And there is no evidence has not been led.
Where is your statement of assets and liabilities?
Statement of objections I have filed.
Not objections, sir.
Assets and liabilities we have filed before the trial court.
Where is it?
Here I have not furnished, but I am
So,
not.
As per that, what is you're an MBA graduate.
It is stated that merely on the education it has granted 10,000. He is a B graduate, but on the basis of both education, the trial court passed an order to pay.
Please place your statement of assets and also your bank, whatever that is placed
Yes,
before.
we have filed everything before bank statement before the trial court.
Place before this court also.
Yes, I will furnish.
List this matter next week.
Short date may be given.
Next week.
Cell number
A
10.
date may be given, my lord.
List the matter on, yes, 11th.
Yes.
Much.
Cell number 10.
Appearing for the petitioner in this matter, Your Lord. Petitioner is the husband. Petitioner is the husband. The wife had filed a maintenance petition before the trial court, Your Lordship. I was placed ex parte. As per the wife's petition itself, I was not residing in the house, Your Lordship. She has suppressed the fact and she stated that my salary is rupees 4 lakhs, Your Lordship. I placed a salary slip on record which says my salary is only 2,50,000. On that basis, the trial court.
What is awarded by the court?
The court has awarded 50,000, Your Lordship, and 50,000 litigation expenses.
What is your salary?
My salary is 2,25,000, Your Lordship.
What is her salary?
She is a molecular biology graduate, Your Lordship, MSc. She's not taken up any job, so she's not getting herself.
Children?
Your Lordship?
Children are there?
Yes, one. He's 3 years old, Your Lordship.
So, as of now, there cannot be any difficulty for you to pay the amount because you're earning 2,25,000.
Your Lordship, there's a difficulty. I'll also show because I've placed the bank statement and the loan statement on record, Your Lordship. There was a joint house which was taken by both.
How much you're paying towards loan?
50,000, Your Lordship.
Yes.
And
Then?
he's also been paying 10,000 for the child every month, which also has been placed on record, Your Lordship. He has also paid for her education and her brother's education, for which he had taken a loan. So he's paying off those EMIs as well.
Please take, now we can understand if there is any difficulty. The petition is permitted to take out hand summons.
Your Lordship.
Counsel appearing before the trial court and file a memo to that effect. Once the memo is filed, list this matter.
Your Lordship, the execution petition may be saved because a warrant has already been issued. I have no difficulty paying. I only have a difficulty that I was placed ex parte and the maintenance were decided. If it is remanded back as well, I'll just place all my documents and the maintenance may be decided, Your Lordship.
No, you yourself agree that your income is 2,25,000.
Your Lordship, I am also taking.
With 10,000 they can live. You also accept that the wife is not having any income.
Your Lordship, I have a Delhi High Court judgment as recent as 2024, which
There are
says that
so many judgments. Will not go off the judgments. We know
Your
how
Lordship,
this
I'm
works.
ready to pay for the child and the wife, but also all the other expenses in my assets and liabilities may be taken. That's my only reason
That's
why.
what we will take care of it once the respondent comes.
As
There's
of now,
nothing to stay now.
while the stay is given, at least the maintenance
pay
amount
for-
may be reduced, Your Lordship. He already has expenses and he's also bearing the expenses which 2 years back, he had also taken some money from his family members for because she was pregnant and there was some difficulties in her pregnancy. So that also took all the financial needs were met by the petitioner. He's under a lot of financial distress and that's the only, he's not saying he will not pay her the maintenance, but all his expenses may be taken on record before the maintenance is decided, Your Lordship.
Now, what is the percentage of maintenance that is awarded?
25% of the net worth.
That is permissible.
But also on the basis of the assets and liabilities. In this case, the 50,000 value was decided without considering anything on record.
Then if it is considered also that the same will be granted. That's why I don't want to reduce it now.
Your Lordship,
Yes, please file a memo, we'll hear it.
11.
Yes.
Deepa J for petitioner.
Yes.
My lords, an order is being passed on an IA filed by me.
Where is that?
The
Which number?
IA is at page 26, annexure B, my lords. Already I have overnight visitation with the child. Here is a case where your lordships had already interacted with the child and the parties.
We'll see, take out notice and summons.
My lords, tomorrow the matter is before the trial court. If there be a direction that I be, my lords, a
There'll be
date,
a direction to,
I'll take notice, my lords. If the notice could be handed over to me by the end of the day, or
it will be done.
tomorrow
And
I'll,
summons
sure, my lords.
on the counsel appearing for the
A
respondent.
specific
Once the
date
memo
could
is
be
filed,
given, my lords.
once the memo is filed, list the matter.
Cell number
Much
12,
obliged, my lords.
Raghavendra Shanai.
Lords, I'm appearing for the petitioner husband, my lords.
Mm.
I initiated proceedings under the Indian Divorce Act, my lords, against the respondent. My lords.
Where is
Respondent
the
is my
impugned
wife.
order?
Impugned order is regarding, my lords, where I was directed to pay US dollars of 1,500, which is about 1,32,000 to the respondent, my lords, per month. With your lordships will find that at page 17, annexure A, my lords.
I see
While
that.
passing of the impugned order, my lords,
What is your salary?
my lords, my salary is about 1,68,000 per month, my lords. What has been ordered is about 80% of my salary, my lords, which is about 1,32,000.
Where is the consideration? Where is the appreciation of this fact that your salary is 1,60,000 and
68,
quoted
my lords, I
granted
filed my
1,32,000?
assets and liabilities, my lords. The respondent
In the discussion,
at page 87, my lords.
earlier, she admitted that the petitioner used to pay an amount of rupees $2,800 per month earlier.
That was in 2019 to 2021, my lords. When I was employed in the USA, there I was earning around 9,000 US
Oh,
dollars.
you're in
my lords.
India.
Now I'm in India, my lords. I have been
That is not considered by the court that you're in
that
India?
aspect has not been considered.
Have you said so that you're
Yes,
in
yes,
India?
please, my lords. I have said it. After coming to India, my lords, my income is about 1,68,000 rupees, my lords. And I have come to India in April 2024, my lords. Court has
Para
considered.
number 12, the said affidavit will show that the petitioner got an income of rupees 2,32,650 in gross.
Gross, my lords. Net income is 1,68,000.
To the tune of rupees 6,000, 6 lakhs per month. This 1,000, you shown the income of the respondent?
Yes,
To
my
the
lords.
tune of
About
rupees 6,000. She's earning,
she's earning. Yes, she's a beautician, my lords. According to me, she's earning.
and she earns 6 lakhs per month.
Please, my lords. About $3,800 she earns, my lords, as a beautician
Where?
in the USA, my lords.
No, she's staying in US and seeking maintenance here.
Please, my lords. That is also one of the grounds, my lords. In my divorce proceedings, she's filed an application through her mother as a GPA holder. And the learned trial court has granted 1,500 as maintenance, my lords. She's, according to me, she's earning about, and her admitted income is $2,000 per month.
Her husband is agreed with the order on I number 5. In MC number 6262 of 2024 dated 6 August 2025, whereby the family court are directed to pay interim maintenance of an amount of rupees 1,500 US dollars to the wife and the children. Husband is staying in India, husband is working in India, wife along with the children is staying in yours. The husband has filed the MC seeking divorce, and the wife through the GPA, that is
Mother.
her father,
Mother.
Huh?
Mother, my lords.
mother is contesting the matter and sought for the maintenance. Learned counsel for the petitioner submits that he is working in India and his salary is 1,60,000.
68.
68,000.
Yes.
And what is this 1,32,000?
Well, 1,32,000 is the Indian currency equivalent to the US dollars of 1,500.
That would be 1,32,000.
Yes.
Court had granted 1,500 US dollars, which is equivalent to 1,32,000 Indian rupees. He submits that she is sufficiently earning there, and the court, without considering all these aspects, has granted the maintenance. Considering the submission of the learned counsel for the petitioner, there shall be stay of all further proceedings.
If I may, my lords, let the proceedings continue, my lords.
There shall be stay of all further proceedings pursuant to the IA.
Please, yes. I'm grateful, my lords.
IA notice the same hand summons and shall file a memo to that effect by 26th of September. If the memo is not filed, stay granted by this court stands vacate.
Yes, I'm grateful, my lords.
Preliminary hearing B group, serial number 13. MB Chandrakuda for petitioner.
Pass
Yes.
over.
Cell number 14, disposed 15. Rashid Khan for petitioner. Shanmukh Reddy.
Here in this case, some anomalous situation has arisen. I have filed this petition for enhancement. During the pendency of this petition, a order has been passed by the Honorable Family Court modifying the earlier order, Lordship. Now I'm seeking some time for filing amendment application so that I can
There can't
question.
be amendment application. You have to file a separate writ petition questioning that order.
No,
You can't file an amendment petition in this order.
for enhancement, it continues, Lordship. As well as I have to question that also. Too.
Because that enhancement should be from that amount, but not from virtually this petition is the instructions. You have to file a separate writ petition for that. Yes.
Your Honor. Your Lordship, I'll file an application for withdrawing. Kindly have this matter tomorrow so that party, I'll invite the party tomorrow.
Withdrawal, you don't have to file withdrawal.
I'll
On
with
the
liberty.
facts, I can pass an order. It can't be adjourned. Yes.
Your Honor, the matter is being dragged by the party. They've taken 17 adjournments in the trial court, and this honorable court granted them 5 days to present their case. They declined on all 5 occasions and adjourned all 5 times. Not only that, based on these adjournments, I approached this honorable High Court, and I was granted an order in my favor, directing the family court to expedite the matter.
Lordship,
Despite that,
I'll intervene. Sorry for this.
order is here.
I'll withdraw this petition with liberty, Your Lordship. Right.
But despite this order, they continue to block my petition in the family court to the extent that the hearings have not been able to get started. So my humble request is to set a time frame, like same honorable judge, Mr. Yerur has set a 20 days time frame in another matter. And similarly, Honorable Judge Sri Krishna S. Dixit has given a time frame of 3 months for another matter which was being dragged like this. So that is one. And although their petition has already become infructuous because the order has already been modified by the trial court after 7 months of intense debate where they did not let the case proceed.
So what are all these orders?
These are the similar orders where the
Not required. Is
Okay.
it in your case or not?
Your Lordship, on the basis of the judgment passed by Your Lordship, we have filed for the payment of all the arrears of the amount. He has not at all paid any amount from the date of the order. Only meager amount has been paid. That has been considered. There are 2 IS which have been considered by the family court. Those orders we did not get. On 28 only orders have been passed, Lordship.
This is the false statement. This is the false
I'll
statement.
get the order and I'll make some amendments, Your Lordship, if possible. Otherwise, I'll withdraw the petition, Lordship. There are 2 orders have been passed.
The present writ petition is filed, seeking enhancement of the present writ petition is filed, agreed by an order. Passed in IA number IA number 3, NMC number 5860 of 2021, dated 12th February 2024, whereby the court had granted maintenance of an amount of rupees 30,000 per month from the date of order till final adjudication of the petition, and one-time litigation expenses of rupees 25,000 from the petitioner, from the husband. The husband has filed MC number 5860 of 2021, seeking divorce. After this order is passed on 12th February 2024, husband has filed an IA seeking reconsideration of the said order, and the court, by order dated
22nd of August this year.
22nd August 2025, had reviewed this order. In view of the same, nothing remains for consideration in this petition, as the petitioner has to question the said order if he is aggrieved. Then next, the party in person submits that on 16th April 2025, a coordinate bench of this court has passed an order whereby the fourth additional principal judge, family court, is directed to dispose of the proceedings expeditiously by providing reasonable opportunity to both the parties to put forth their case. Further, both the parties shall cooperate with the family court in disposal of the matter. In case of any unnecessary adjournment sought for.
Lordship, my submission. Arrears he has to pay on the basis of judgment passed by your, I have filed an IA. Now the family court has been,
I'm only looking at this order.
please, Lordship.
Other parties, the family court is at liberty to impose exemplary cause. When there is an order on 16th April 2025, it is a case of the party in person that in spite of that, several adjournments are sought, and the family court had liberally granted the adjournments. In view of the same, this petition is disposed of, giving liberty to the petitioner. Number one, the WP number so and so, the I number so and so. In view of the subsequent order, nothing survives for consideration. Number two, in the light of the order dated 16th April 2025, the Honorable Family Court shall strictly act in accordance with the law. Yes.
So far as arrears payments are concerned,
Yes.
your Lordship, order has been passed, otherwise that will be stalled there on the basis of this order. An order has been passed for payment of the arrears of amount.
Your
Now
Honor.
by taking the help of this order, you will not be going to pay the arrears of amount.
Your Honor,
Now
the family court has
the
given a
London family
date
court has
for the
passed the order,
payment
Lordship.
that will be adhered to.
Let him pay whatever the order pass, comply the order, Lordship. Otherwise, in view of this order, you will not going to pay any arrears of order.
Number 16.
Therefore, the clarification, Lordship.
I have not said anything. I only said.
No, regarding payment, your Lordship.
Why should I say about the?
My submission may be recorded so that whatever
will-
the
I
order
will not
passed by
write-
the, no, order,
It's in a record. I will not pass any order. Learned counsel submits that. In the light of this, it is submitted that my husband is not paying the maintenance.
there is
and an
already an order.
And an application is filed.
Pass an order.
That's a false statement, Your Honor. Maintenance.
Already order has been passed for payment of the amount. In view of this order, Lordship, he will not going to pay any amount to me.
Your Honor, the trial court has given a date of 19th
Whatever order,
September.
let him comply. Whatever order passed by the Honorable Family Court, that has to be complied by him.
Yes, that will be
Otherwise,
complied.
take the help of this order,
What is it? What is this order?
whatever,
is this order?
in view of the judgment passed by your Lordship,
What is that?
I filed an application before the Family Court, your
Then,
Lordship.
what is the order passed by this court? What advantage will
Yes,
it take?
till he pay the arrears of the amount, proceeding will be stayed, your Lordship. That's what, the basis of judgment passed by your Lordship, I made an application before the court,
That the
staying
court
for,
will-
staying
that
for the
court will-
proceeding.
I didn't say anything, Mr. Counsel. Please understand what is the order passed by me. I only said this court has passed, a coordinate bench of this court.
Your Lordship
has
has
passed an
observed,
order.
your Lordship, that expeditiously and cooperation has to be done.
I have not said so. That is said by the earlier bench. That's what I repeated. That order is passed. I didn't say anything. I only recorded the earlier order.
No, at least direct the Family
Not
Court.
direct anything.
Number 16.
Yes,
Ajkumar
next
Gowda.
matter.
My lord, council on record not in station and press time.
What is that?
Council on record not in station.
Let's
Kindly
see the
permit.
order. Give that docket. Even on the last occasion and today also, there is no representation on behalf of the respondent. Counsel for the petitioner seeks time. Interim order earlier granted is extended until further orders. This is matter in the month of December. Don't give the date. Yes, next.
Number
Publish.
16. Chandranath Ariga.
Lord, the parties are trying to settle the matter, my lord, and the matter is listed on 4/9, my lord, before the trial court. Before.
It's listed for settlement minutes.
Both the parties submit that there is a lack of settlement And the matter is going to come up before the court on 4th.
4-9.
On 4/9. List this matter on 16th.
Please, obliged.
Till number 18.
18 is adjourned.
No, no.
Petitioner in this case, a week's time may be granted. Senior is not well. Moreover, the respondent number 2 is attained majority in last week. I filed necessary application to discharge the guardian.
Respondent is a daughter. Question of attending majority, it will not take any issue.
Is he complying with the interim order?
Yes, madam.
Your interim maintenance was awarded only for 6,000.
That's whatever is the interim order, is it complied with or not?
It was complained, my lord, but if the 3,000 is only paid, so the wife is not working, and minor son is still under care of the mother. Since last
This is matter on Tuesday. Yes, next.
Till number 19.
Interim order granted earlier extended.
Interim order all granted is extended till then.
19. Bindu, you.
For the petitioner in this case, my lord.
BB.
ಆಗ್ಬೋದು. One clarification is required as regard to order dated 13/8/2024, my lords.
What clarification?
In that case, as regard to the child's maintenance, my lords, apart from the school fee, yearly school fee, 10,000 has been fixed and the respondent father has been directed to make the payment, my lords. So on last occasion also, for making the payment, there was some issue saying that that is not for every year. So that may kindly be made absolute, my lords.
Fine. 1 year, the father's responsibility will be, no, it says that educational expenses are only for 1 year. Educational.
It was requested for him to make the payment, but there was
I'll
some
record both
resistance.
your submissions and I say that earlier order with regard to educational expenses every year.
Please, my lords.
On 38/2024. You shouldn't, 38/2024, an order, then why are we keeping it pending?
There's one more connected matter.
Connected
Why it is disallowed maintenance?
Vice
That's my
maintenance
friend
is-
wants to argue some other date, that's all.
Why argue? How many days?
I'm ready
Then
to-
this we will dispose it of.
Which one?
With the light of this arrangement, we'll dispose it of, let the
No,
matter
no,
be
both
heard.
the wife has been rejected maintenance, my lords. As far as that point also, wife
This is
is
on
in appeal, my
visitation,
lord.
no?
Both matters, my lords.
No, very odd. Let's see the impugned order.
So as
in
regard to
19.
the father's petition, that is only with regard to child's maintenance, that can be disposed of,
That's
my
what
lord,
I'm
by
saying.
fixing.
19
But
will
there
dispose
are
it of.
arrears before, much before that also, that has not been considered here in this order, my lords. Only from that 2024 only, that arrangement has been made, my lords.
When did you file the IA?
My lords, on the same 2018, my lords.
Huh?
Both for the mother and the child, my lords.
When something is ordered, when maintenance is ordered to the child, then it should be from the date of the application, but can't be from 2024. Whatever arrangement that's going on, it should go back to, come to the impugned order, page number.
Page number 19 of writ petition 17612, my lords. Operative portion of the order is at 34, my lords.
Yes.
IA number 4 filed by
Petition is
the
hereby
respondent.
directed to pay monthly interim maintenance of rupees 25,000 to his daughter.
By name Tanvi Harish from 2/1/2018 till the disposal of this petition.
Then what is the problem?
No, this arrangement has been done only from 2024, my lords.
So
Earlier arrears has
now,
not been finalized.
What we do is, not this is, now what are, the order is 80,000 plus educational expenses. So this should relate back to 2/1/2018.
Please, my lords.
After the matter was heard, my lord, education expenses was not an issue. My lord intervened and said, Mr. Raju, your client has a responsibility to pay that. We said yes. So therefore, from my lord's date, we are paying that.
How much is, how much is, how much are the?
1,80,000 rupees per year. 1,80,000 rupees per year.
1,80,000. 1 minute.
Small fire.
We'll just see what is, how it would be per month. It comes to 15,000.
15,000 rupees have been
So,
paid.
no,
10,000.
it comes to 15,000.
Yes, ma'am.
Plus, this court has asked you to pay 8,000.
10,000, 10,000 per.
I'm paying.
8 or 10?
10,000.
10,000. It's coming to 25.
Yes, ma'am. That is the observation what was made
So
by this.
what happens is, The same will be, what the trial court has directed you to pay 25,000. They have come in appeal before this court. Now that order is being confirmed in the same sense, 10,000 per month and educational expenses. It would be one and the same. Or if you wanted 25,000, then you pay 25,000. Because you have not preferred any writ petition against that order.
I have prepared, I've challenged this also, not because the reason I challenged was that I was not even given the right of visitation. My lord said that is a different aspect, Mr. Raju. Payment of the school fees is your primary responsibility. I bowed down to my lord's opinion and I advised my client to pay it. We are paying it.
By order of this honorable court, visitation rights has been granted to the father, and
Subsequently,
every Saturday
after
and
my
Sunday
lord's intervention, it was granted. My lord.
He's coming and seeing the child also, my lord.
So it is going on. It is going on well.
Since last year, 2020.
After my lord's intervention, I was granted that. From 2014, only when I came before this court in 2024, first 10 years I was not granted. After my lord intervened, only then that visitation rights I got. Now I agreed, okay. And then my lord said, pay the school fees, I paid. I did not budge on that. And in fact, when I tried to say, my lord said, no, nothing doing, you have to pay, I paid. That is the position now.
Because now even if the visitation is not granted, when the father is capable of maintaining the child, we cannot say that because visitation is not granted to the father, so maintenance will not be paid.
That was my lord's opinion also. Mr. Raju, you cannot project that to say that you will not pay, and I obeyed my lord's order and I told my client to pay.
So now we have to dispose this off.
Yes, ma'am.
So when we have to dispose this off, then any order that is passed by the court should relate back to the date of application.
Well, then what happened?
Get instructions from your
I paid
client.
10,000 from 2018, Malad.
That's what I'm saying. But what will happen to the educational expense?
Educational, because she joined school only 2 years back.
Is it so?
No, my lord, child is studying in the 7th standard as on. She's 11 years old as on today, my lord.
She's in 6th standard. She joined about two years back only. The school fees was this much. From the beginning, my lord.
No. You say she's 6th standard and 2
I
years
didn't
back.
know.
2 years back, how can she join in 2 years back? She must have joined 8 years back.
6 years back, she must have joined. 6th standard, I don't. Last 2 years, I've been paying, my lord.
So another 4 years before that.
Another 4 years at 10,000, I will pay whatever is the arrears at 10,000, I'll pay. That would be a fair way of
School
looking
fees
at
also
it.
has to
And
be
my lord,
considered.
in this case, I demonstrated before this court what is her.
No, we'll do one thing. This 10,000, let it be because he'll be paying from the date of application and continue to pay the school
Along with
fees.
the educational expenses.
No,
my
no,
lord.
continue.
The
Let
very
him continue to
model
pay.
from 2018. my lord.
Henceforth, my lord.
What is happening from 2018 to 24 without deciding this application?
I mean, since from the year the child joined the school, from that year onwards, my lords.
No.
If your
When you
lordship look
filed
into the order dated.
initially when you filed the application, let us see what is that.
Yes, my lord.
Where is that application? And what did you sort?
Application is Annexure B at page 35, my lords.
35.
Yes, my lords.
Application was
I
delayed
sought for,
because
it
HDFC
is,
bank statement which is suppressed.
lordship got it, my
Business
lords.
came to HDFC bank statement which is suppressed.
Hmm.
And my business came to standstill.
Please to grant interim maintenance at the rate of 2 lakh per month to the
Lakh per month to the
respondent and the
respondent, the
minor
minor
child.
child
You
litigation
didn't ask
expense.
for educational expenses.
At that point of
To the
time,
respondent and the minor child and the litigation expenses. Like that, I have informed. And in my affidavit,
And
I
where
have
did you say
stated.
about the school education and other things?
that was raised before my lord for the first time, and my lord said, pay. I said, I'll pay.
Yes. In the entire petition,
Para
you never
15
ma-
of the petition,
Para?
my lords. Para 15, I have.
There is no para 15, it's only.
On page 10, my lords, in petition 17612 of 24, my lords, in my petition.
No, I'm looking at page number 35. That's the application filed by you.
That's the application, my
So
lords.
affidavit is next page. That is husband's application.
No, my lords, page 35, that is.
What is the name of Vanati?
Vanati
Rajko?
is
Yes.
the wife, my
Your
lords.
affidavit in support of the IA.
Yes, my lords.
In that you don't say anything about the education.
Because just she has been thrown out of the matrimonial home and to her parents' house.
So-
And very next day, the notice of the summons has been served on her. And at that period of the time, child was minor, 2 years old only, my lords.
That's what I'm
At that
saying.
point,
So
yes.
now you cannot say you should relate back to 2018. That day there was no
Educational
requirement of medical
expenses only
expense.
from the LKG class only, my lords.
You didn't sort for it. Where did you sort for that? You didn't even see, you didn't ask for the maintenance to the child at all.
Yes,
You
my
only
lords,
asked for yourself.
Application along with the 24 and 26. Grant interim maintenance also to the respondent and the minor child, my lords.
Yes.
Clubbing both, my lords.
So what we do is, let him continue to pay that 10,000 till from 1/8, what is that application date?
2018.
Mm.
1/1/2018.
1/1/2018, and let him continue to pay the educational expenses.
From the LKG standard.
Any of two,
onwards.
no.
My lords.
Please get instructions from your client. I'll dispose of this petition.
Today itself, my lords.
Tomorrow or Tuesday?
Next week, 10th, my lords. 10th.
This is matter on 10th. Then what about the next also that day you argue?
Yes, please.
19.1 also.
Please, ma'am.
Both the matters post on 10th.
Till number 20. Manjunath V. Rayappa for petitioner. Anita
Yes.
N.
On record advocate is not well. On record advocate is not well. There's proxy counsel. Press times.
No interim order in this. This is matter on 19th of November.
Till number 21.
But there is no interim order. That's why you take your steps. You file the EP. Huh? It's difficult for the court to give the short dates because I have to complete the list. Till now I'm at 2183 or the matters. Finally, leaves the matter on 19th. At the request of the petitioner, no further adjournment will be granted. 9th September.
Yes, ma'am.
Yes, next.
Cell number 21.
For the petitioner in this matter.
For the respondent, my lord.
Matter, Lord, has been complied with. Regular payments have been released, Lord.
Let's hear the matter itself.
Please.
Yes. Where is the impugned order?
Impugned order, my lord, is at page number 24.
24. Respondents are directed to pay jointly and several. Who are respondents?
Respondents are the so-called husband and the son, my lord.
Are directed to pay
Please.
20,000.
The marriage is under dispute, my lord.
20,000
It is not about the marriage, my lordship.
to petitioner from the date of application, that is 19/8/2022. What is the age of the parties?
Parties, my lord,
Wife,
first
she is
petitioner is
63 years old.
So she is about
Husband
65
is
now.
74 years old.
78
Son is
years
34
now.
years old. Let's see what is the case of the wife. Come to the petition.
Lord, main petition, my lord, page number 56.
Then where are your objections to the main petition?
My objections, my lord, page number 64. my lord.
Yes.
From paragraph number 7, it starts, my lord, 65 page number. May I read?
So you're disputing the relationship.
Please.
What is the basic document? Any documents are filed?
No document. As far as the marriage is concerned, are having lived together for so long years, my lord. They say that from the year 1981 they are in to relationship. There is no document forthcoming, and only
And
document
what
they
are
have
your
brought.
documents to whom you are married? Who is your wife?
No, he is a bachelor, my lord. He is a bachelor, and the
Son, that other
son,
person?
my lord, he has taken in adoption by the first petitioner. The very respondent has given in adoption to the first petitioner. This is what the case, my lord.
My lordship, this
No,
is,
it doesn't look something so simple as you're saying. You say, now the son which is with you is the son of the lady.
There is no dispute as far as that is
And you
concerned.
just like that, you have taken him in adoption.
No, my lord, petition pleadings may kindly be seen, my lord.
Mm. Which paragraph?
Paragraph number, page number 57, paragraph number 3,
57.
57. my lord.
Mm.
Erstwhile, she has married and she has a son.
Mm.
Paragraph number 3, my lord, 57.
Ah.
It is submitted that the petitioner was married to first respondent Hanumanta Gowda on so and so. This is the first petitioner herein at Chamundeshwari Temple, Mysore. Prior to her marriage with the first respondent, the petitioner had married one Satyamurthy who died in the road accident on 1981 at Chennai, and the petitioner is having a son by name Vijay Kumar, born on 4/4/1981. From the first marriage, after the death of the first husband, the petitioner came to Bangalore in the year 1983 in search of a job for her livelihood. Rented the house belonged to one Vasdev Murthy situated at 7th class so-and-so address. Knowing about all these facts, the first respondent had married to the petitioner without knowledge of his family members, stating that his family members are very orthodox and they may not accept the widow with a child as a wife to him, and he made the petitioner to stay in the same house at
From
so
the
and so
earlier
so and so
marriage,
is the
from the earlier marriage, she has one issue.
yes,
From this marriage, the second respondent.
no,
According
there is
to
no
her.
marriage at all.
According to her.
According to her, and as far as the death of the erstwhile husband, my lord, there is no document forthcoming, and everything is mysterious. I have taken all the contentions in my statement of objections, and my lord, there is a domestic violence petition also filed, wherein, my lord, I have filed a memo.
Anyhow, at this stage, we cannot go into all this.
Please,
my lordship,
please,
the case is pending in the trial courts, my lordship.
that is obvious, and my lord,
Now, please come to
No.
the quantum. What is this second respondent doing?
second respondent is working, my lord.
Mr. Siddhartha.
Yes.
His liability, my lord, towards his mother cannot be denied. It is admitted fact. He is the biological son of the.
Now, even as far as you are concerned,
Please, my lord.
that is yet to be decided. You
Please,
are-
my lord, that's true.
You are the
That's true.
father of her child.
No, my lord.
No.
No, that is under dispute.
Adopted father.
Adopted father, absolutely,
Adopted father.
absolutely.
Yes. So, what do you do? What is your income?
My lord, he is a retired person. He is a retired engineer from the PWD. He is
How much
getting
pension you are getting?
23,000 rupees or something. Is I have placed a record before your lordship, my lord.
No assets and liabilities are filed, my lordship.
Huh?
No assets and liabilities are filed before the court.
And what is you represent?
Both of the petitioners.
What is the income of the son?
About 1,10,000 rupees he is getting, my lord. He has been married, and there are two sisters of the first petitioner. They are old.
That's why the court said jointly and severally. You pay 10, he'll pay 10. Or you pay 5, he'll pay 15.
The son, I will instruct him to pay totally 10,000 rupees, my lord. Accordingly, let it go on, and on merits, the marriage be disputed.
My lordship, sorry to interrupt. Page number 148, he has filed the assets and liabilities, and it says he is drawing monthly income of 1,38,685, my lordship.
Whose income is that?
Siddharth, the son.
Yes.
And last time, my lordship has ordered this interim order on 13/8, my lordship, 38/2024. Well, my lordship only ordered to get the first payment. We have to bring her in ambulance. She was brought here to the court in ambulance to show that she is alive. My learned friend was insisting her presence. So on that, after 2 months of the order, my lordship, we got 1 lakh.
Yes. What is that?
the first petitioner, my lord, has two sisters. They are spinsters. They are old, as old as 80 years. All of them have no income. It has been, all of them has been taken care of.
Then in that case, ultimately she wants 20,000. Let
Yeah.
your son pay 20,000 with this 4 lakhs income.
No, my lord, she has another son also as per her own
No,
pleadings.
Another son is
Son
very
who
meager
is
income he's getting.
Is having income.
No, he's getting very meager income.
Yes.
Yes, that we have
Please
given.
come.
Just confirm the trial court order, my lordship.
Lord, may kindly be peruse these documents, my lord.
What are the documents?
The spinsters, they don't have any income, and no, that they also has been taken care by the second petitioner. Lord, may kindly be considered. 10,000 rupees.
No,
I'll
he will
insist.
take care of
By the first petitioner, my
spinster
lordship.
uncles, I mean,
Yeah.
aunt, but not the mother.
No, mother, I'm agreeing, Lord. 10,000
Let him
rupees.
pay 20,000.
No,
How will she live
20,000
in-
rupees too high, Lord, because records may kindly be seen, Lord.
My lordship, he is getting about 1.5 lakhs.
Fun complete.
Yes.
Simultaneously, I can't hear like that. Yes.
Sorry, my lordship.
He has loan liability, as well as he has one small daughter. He has married. He has his own family and is living separately. Rental liability is also there for him. All these things are there, my lord. In this count of the matter, my lord, the first petitioner's pension record may kindly be seen.
That's why we will not ask him to pay. We'll not ask him to pay.
Please, my lord.
We'll ask only second petitioner to pay.
Second petitioner, 10,000 may be reasonable, my lord. May kind.
Petitioner 4 lakh is his income. As per the statement of assessment.
No, not 4 lakhs. my lord.
One point,
Come to that.
1.38, my lordship. Page number 138.
Please come to 138.
Sorry.
138 is.
Sorry, my lordship.
1,38,000.
148, my lordship. 148.
4 lakhs. And for his marriage also, he has secured loans. He is
Where do you get that amount?
Page number 148. my lord.
148. Yep. There I have details of income of the dependent.
1,38,365.
6 day. Yes, my lordship. No, that is in 2024. Maybe now it's increased close to 1.5 lakhs. That's what I'm telling my lordship. And his mother is having a lot of medical issues, my lordship. She had a heart attack after this receiving the first payment. She is every day getting treated by the doctors, and her medical expenses so much. So that is why we have been insisting on the confirmation of the trial court order, my lordship. 20,000 is not a big amount for a son to take care of his mother.
For 150 may kindly come to me. Lord. Details of the liabilities of the second petitioner.
Yes.
Lord, the first item, there are hand loans of rupees 10 lakhs and actual amount borrowed so and so.
What are the documents, the supporting documents that are filed before the court with all this, with regard to all this? Yes.
Hospital expenses of the petitioner's second petitioner's sisters may kindly be seen, Lord.
Second petitioner's sister.
Yes, please.
There is no sister for
The first petitioner's sisters. Now I have produced.
They are becoming the aunts, my lordship.
May I take your lordship
He can
through.
take care of the medical expenses of the aunt, but not the mother.
He has been burdened like that, my lord. That is what my submission.
Then in priority, mother comes first.
Please, my lord. That is why, my lord.
Let him take care of the mother. Leave away. You will take care of your sister.
The respondent, my lord, has another son. He is also earning. That income proof, etc., has been held by the respondent.
Please go. Agreed with the order passed in I number 2 in criminal miscellaneous number 581 of 2022, dated 16th April 2024, whereby the court had granted maintenance of 20,000 to be, which is payable by the husband and the son. The present petition is filed. The wife had filed the petition seeking maintenance of an amount of rupees 25,000 per month, an interim maintenance of 25,000. This is IA order in IA number 2 in criminal miscellaneous 581 of 20. 25,000 as legal expenses. According to the parties are referred to as mother, husband, and son. It is a case of the mother that the son and the husband are having enough income, and she is not in a position to maintain herself. It is stated that she is married earlier, and out of in the said marriage, she has one son, and later she is married to the petitioner, first petitioner herein, and in the wedlock, the second son is born. It is her case that both of them are not taking care of her. Next para. Let counsel appearing for the petitioner, father, and the son, appearing for both father and son, submits that the court has they have disputed the relationship. They were never married. No document is placed before the court to show there was any consummation of the marriage. However, he does not deny the fact that the second petitioner herein is the son of the respondent herein, who is the mother. He says that he has taken this son in adoption, and it is submitted that the father is a retired person and he is having he is getting 20,000 and odd pension.
28,000, my lordship.
Huh?
28,000.
28,000 as pension. The son is earning 1,38,685, but he has several other commitments. He has taken lot of loans. He has to repay the same. Further, first petitioner sisters, that they are the aunts of the second petitioner, who are spinsters, and he has to take care of them and their medical expenses. In view of the same, first, she is not entitled for maintenance as there is no relationship with the first petitioner, and secondly, the amount that is granted is on the higher side. Next para. Learned counsel appearing for the respondent mother submits that both of them are sufficiently they are having sufficient income. In fact, in the recent past, she has suffered a heart attack.
Yes, my lordship.
Heart attack, and she is undergoing treatment. She is in a dire necessity of the money, and the other son from the first marriage is not doing good in life. As such, he is not in a position to support the mother.
Financially.
Hmm?
Support financially.
Support her. Next para. Having heard the counsels on either side, there is a material on record. The dispute with regard to the relationship of the parties, the court cannot consider in this application, and the court had rightly granted interim maintenance. Coming to the quantum of maintenance, it has asked both the father and the son to pay 20,000 together, jointly and severally. The father is, according to him, his income is 28,000. His pension is 28,000, and her son has so many commitments. Whatever the reason, considering the health condition of the respondent, of the mother, it is the responsibility of both the parties to maintain her. Hence, the amount of maintenance that is granted by the court, that is an amount of 20,000, is a reasonable amount. From that, 8,000 shall be paid by the father, and 12,000 shall be paid by the son. That is first and the second petitioners. Accordingly, with this clarification,
My lordship, will be increased.
Huh?
Lord, instead of fastening the liability against the first petitioner, Lord, let it be against the son only, and Lord, may kindly be reduced, Lord. 20,000 is a burdensome amount for the.
I said, that's why let's not burden the son. I said 12,000.
No, no,
My lordship.
no. See, my lord, marriage is under dispute, and there is a order.
Be decided by the
Please, my
court.
lord, let
My
it be
lordship.
decided. Until then, my lord, let there be a burden against the first petitioner.
We can't
Lord,
decide it.
My lordship, the amount
may
is very
kindly
less, my lordship.
confined. May kindly be.
Yes.
20,000.
Oh, then what do you expect the court? Where is your writ petition?
No, sorry, I didn't.
12 plus 8.
Allah,
Much obliged, my
Lord,
lordship.
20,000 is a very high amount, my lord. May kindly be
Only two
restricted to
options.
15,000.
Only two options. Either entire the second son will pay, or you pay.
Please, my lord, please, let it be like that. At least, my lord, may kindly be confined to 15,000 rupees. It will be a overburden to them, my lord. That is what the reason.
The amount of maintenance is reduced from 20,000 to 15,000, which is payable by the second petitioner.
Obliged.
My lordship, you reduced it by 5,000.
Yes. You need to, somebody has to pay.
Hellacious.
Paper order is not sufficient.
Okay, much obliged, my lordship.
Father.
My lord, I appear for the.
I appear for respondent, my lord.
Yes.
Here, they have not obeyed the orders of this honorable court. That is annexure J which they have produced, my lord. Page 53 to 56, my lord.
Submit, my lord.
Where is the order?
Lord,
Annexure J, my lord.
No, you say that the order is not complied. No interim order by this court.
No. Already one writ petition has been disposed by this honorable court, my lord. And this honorable court has clearly said that if the arrears are cleared by the husband, MC shall be disposed of within a period of 2 months.
So that is a different aspect. What is the impugned order now?
Here, earlier order they asked
Where
to
is the
reduce
impugned order?
the maintenance.
I'll submit. Lord, the
order dated 19 July 24, my lord.
Let him argue.
No, Lord, I.
Yes.
Lord, is the husband's petition. Lord, I'll briefly narrate the facts so
No,
that
before
it can
that, please show
No,
the
Lord.
impugned order.
My lord, impugned order, your lordship finds it's at annexure A. This is the memo of calculations. Now, their memo of calculations says that 18 lakhs is due. This is what they are due. May I read, my lord?
Arrears of maintenance, 18 lakhs.
18 lakhs. Arrears. Now, that's the reason I wanted to briefly narrate the facts of the case so that it becomes clear, my lord. That's the reason. My lord, before we look into that, this is a husband's petition, divorce petition, which has been filed in 2014. Ultimately, it was transferred to Arsikere. In Bangalore, it was filed. Then it was transferred to Arsikere. And during the pendency of that, the wife filed a criminal miscellaneous petition, which is at annexure C, seeking maintenance. That your lordship finds, where she has said, ask for maintenance and other things. Now, if your lordship turns to page 32, annexure E, please turn to page.
Yes.
That for the reasons stated in the accompanying affidavit, the applicant humbly prays that the court, honorable court, may be pleased to grant a maintenance pendente light and expenses of proceedings in total of rupees 30,000, the above case, in the interest of justice and equity.
Yes.
So what they have said is pay 30,000 during the pendency of the proceedings. Now what happened was, then an order came to be passed, which your lordship finds it at annexure H.
Page number?
Page number 46. But please go to special page 2047, my lord.
The petition is directed to pay 20,000.
Present application is filed by the respondent under section 24 of the Hindu Marriage Act, seeking maintenance pendente light and expenses of the proceedings of rupees 30,000 from the petitioner. An order comes to be passed. If your lordship turns to page 51, IA number 1 filed by the applicant respondent under section 24 of the Hindu Marriage Act is hereby partly allowed. The petitioner is directed to pay 20,000 per month to applicant respondents towards interim maintenance and cost of the proceedings from the date of the petition till the disposal of the case. This is what the prayer that was sought was for the pendency of the application proceedings application from the date of the application. But order came to be passed saying that you pay from the date of proceedings, commencement of proceedings, which is from 2014. That was challenged by me before this honorable court, and your lordship was yourself had heard the matter, and an order came to be passed, which your lordship finds it at annexure J at page 53, my lord. That's the impugned order. Within 1 week from the date of receipt of the copy of the order, the wife shall file the details of the amount that is received by her, and the husband, if at all, wants to file any objections within 1 week from thereon. If the arrears are cleared by the husband, MC shall be disposed of within a period of 2 months from the date of the amounts are cleared, disposed of so and so. This is the order which has been passed by my lord.
So the court has not interfered with any of it.
My lord?
The court has not said anything in this order.
No, nothing has been decided, my lord.
So it is from the date of petition.
So what happened was, because nothing was said about that particular aspect, this petition was filed when the husband had lost his job. And that was the submission I made. Because I have lost my job, I am unable to make the payment. But irrespective of that, right from the date of the petition till today, the petitioner, the husband has been paying maintenance of 20,000 rupees even up to the last month he has paid. There's no dispute about it. The only question which has to be decided is whether it is from the date of the filing of the original petition.
Why it will be decided now when
Lord?
when the order is passed?
My lord.
When you question that order before the court,
Bless
when it is not clarified by the court,
Yes.
or when the court when it is not even argued before the court,
My
in a
lord.
piecemeal business, how this court will clarify it now in some other case?
No. What I'm submitting is when the matter was heard, if your lordship turns to, this was my contention before the trial court. Please go to page 19, 2 lines from the top. There is a judgment. The learned counsel for the petitioner has relied the decision reported in so and so. So far as the said decision is concerned, the court ought to have directed the petitioner to pay the arrears of maintenance from the date of the order and not from the petition. Now, please have a look at the judgments.
No, not the judgment.
Played out.
You have already questioned an order. Nothing has been clarified. How can you file a writ petition seeking such clarification now?
What I'm submitting is this order which has been passed by the trial court has not taken into consideration the judgment of the Honorable Supreme Court, which said that it has to, any maintenance, interim maintenance has to be paid from the date of the filing of the application.
When is
Application
the
is filed on 10/1/2023.
Then from that day only.
From that day I'm paying. From that day I'm paying.
How can it will go to 2000?
No. It's wrong, man. He has submitted wrong before the honorable court. He told that he is not working, my lord. It is very false. And also I filed my objections.
What he said is not about working or not
because
working.
for that only
When an order is passed,
because
that
as per-
order of interim maintenance will go back to the day when you filed an application seeking interim maintenance. For example, 2014 MC is filed and you choose to file the application in 2023. Court will not say pay from 2014.
No, man, my application was not from the date of my application to be paid the interim maintenance, my lord.
When is your application? That you tell.
That is annexure E, my lord.
Date.
Because 10/1/23, my lord.
Yes, so.
But I have asked from pendent lite. From the date of
Whatever
petition.
you ask, courts can't grant from the date of petition. It has to be from the date of order. That is from 10/1/2021. You can't calculate from 2018. Interim application, it's your requirement. You filed an application in 21. You didn't feel that you require my maintenance from 2018, 14. So when you file from that day only, it will be granted. Why would the court grant from 2014? That's not the law.
No, because they were dragging the proceeding from several years, my lord. Even
Nobody has stopped you.
my criminal petition also, they have not paid any one rupee, my
Stopped you
lord.
from filing an application under IA for maintenance, interim maintenance.
Because I filed application seeking from pendent detain, my lord. So that has been confirmed by this honorable court, and they're not challenged the sort of this honorable court, my lord. And they have not paid arrears.
Now, when it says that, it should be from the date of petition, this application, it won't go back to 2018.
Because trial court has clearly told that it's from date of
That's not,
petition.
that's not correct.
And here
Let him, you file a review in this, I will
and
clarify
one
that.
submission, my lord. Here, he is running a company. He has
Whatever
not
it is,
disclosed. A
whatever
company from 2017, he has got good earnings and also is taking salary of more than 2 lakhs as
File
per
an
his
IA in
assets and
this.
liability.
That is not the law.
And they have only award is only 20,000.
Then
my lord.
I will clarify that.
Please.
Yes. This is matter on 23rd of September. Yes.
Please.
Cell number 23. Mohan Kumari BV, petitioner.
Appearing for respondent, my lord.
Appear for petitioner. Kindly refer to mediation.
Mysore, it may be referred to Mysore mediation, my lord.
Both the parties submit that there is a likelihood of settlement. Parties shall appear before the mediation center at Mysore on 16th. Yes, next.
This
Cell
month,
number 24.
16th September. Please.
Yes, 24.
24.
And for the respondent.
K. Alva, petitioner.
Last occasion, my lord, your lordship directed me to file a wakalat. I'm sorry, affidavit. I filed an affidavit yesterday, but I could serve the copy to my learned friend only today, just now about half an hour.
Again, it has to adjourn. When counsel the respondent submits that as per the order of the court, he has filed the affidavit and the same is served on the counsel the petitioner today. This is matter on 18th.
18th, yes.
18th.
18th of.
Next.
Cell number 25. N. Gautam Raghunath, sir, petitioner.
Respondent. Lord, we've already filed the wakalat. Our name has not been displayed on the cause list. We have filed the wakalat, my lord. Yes.
They filed the wakalat yesterday, my lords. The name.
Okay, we'll record it. That's not a problem for you.
No, my lords. Just wanted to make a submission saying that connected matter in trial court, it was listed on 29th. Amicably, they wanted to settle the matter. The same submission was made, and the matter is referred for mediation, which is happened on, which is to be happen on 18th.
It is submitted that the matter is referred to the mediation, and the same is coming up on
18th.
18th of September. This is matter on 8th of.
My lords, any short date after that, like 20th or something like that, my lords, so that we could keep it
If
posted.
there are
Matter on
multiple, if there are
23rd.
multiple dates of mediation, it might go ahead, my lord. So
Because
first
18th
we
it
took-
won't be there. List this matter on 9th of October. Who is appearing for the respondent?
Kapil Dikshit, my lord.
It is submitted that so-and-so has instructions, has already filed wakalat.
We have already filed.
Registry is directed to print the name. Is 26.
Cell number 26.
Achha.
Judiciary BV, petitioner. Subramania PD.
Petitioner, my lord.
The respondent.
For the respondent in I have filed the wakalat based on the intimation given to the lower court advocate. The petition copy is not served on me, my lord.
Please serve the copy. Then counsel the petition, serve the copy of the petition and the counsel the respondent. List this matter on 10th of September.
Interim order may kindly be
Interim order granted is extended till then. 27.
Cell number 27.
My lord, I appear for the respondent.
File
In the family court, they have filed it for mediation, my lord, on 15th.
My lord, this is the sixth mediation, and in last 2 months, this is the fourth mediation, my lord.
How many times mediation has happened?
My lord, they have filed 4 to 6 cases. Family court 3 cases, high court 3 cases, mayoral and magistrate court 3 cases. The wife is filing n number of cases against the innocent husband. So yesterday in the family court, original suit, he is not representing in the OS case. Judge told 14 years marriage has gone, 14 years son is there. So the mediation on 15/9/2025. Mediation report on 13th October. After 13th October, any date may be given. I am ready to do argument, my lord.
My lord, may I make my submission, my lord?
Matter on 16th October, yes.
My lord, this
in second-
mediation is being referred, fourth mediation being referred in last 2 months
lord,
only because of, my lord,
My lord,
kindly don't take me wrong.
27.1 interim order may be extended.
case?
My
My
lord,
lord,
interim
it's a case
maintenance
of, it's a case of settlement because 14 years marriage has been elapsed. 14 years son is there.
Also permit to say.
Yes,
the
my
same.
lord.
My lord, interim maintenance order has been taken on the submission that his salary is 1 lakh only, whereas his salary is more than 1 lakh 90,000, my lord.
My
So
lord,
interim order has to be vacated at least
if I go,
kindly.
if they are ready to do the argument, then the purpose of mediation will not be served. If I tell A to Z everything what is happening between the husband and wife, then the mediation will fail on 13th October. What is the purpose of mediation then?
The mediation has been only requested, kindly don't take me wrong, it's only because of you, my lord, so that the matter can be adjourned.
No, not, that is not the case. He is
Yes,
not
sir.
representing
Fourth mediation-
in yesterday
fourth
family,
mediation
my
in
lord,
2 months,
yesterday
my
in the
lord.
family court, he is not representing in that case. Okay, another advocate is there. Last Saturday also, husband and wife waited till 4 p.m. for one more mediation because the file didn't arrive from the Mayall court. If the husband and wife, my voice is loud. I don't use my. If the husband or wife are ready to settle, who are we, the judge and advocate between them? Let them, if both the parties have taken the mediation.
She is
date,
here, she
who
is
are
not
we?
ready for mediation.
Huh?
She is here, she is not ready for mediation, my lord.
Then why is it sent?
Because the judge is, they have requesting every time, that's what I'm saying, my lord. Fourth time in 2 months, my lord.
You are not ready to settle the matter.
No, it's not about settling the matter. My husband is not settling the matter. He's deliberately requesting me to the mediation. Mediation, he's telling I will not give her anything, let her fight the court. Fight in the court. That's what
He's,
he's telling in the mediation.
he's saying I'm ready to go to jail.
Every mediation, he says you file any cases, you fight it in the court, I will see you in the court only.
If
I
that-
don't know why his advocate is continuously asking for mediation.
If that is the case, yesterday they would have told no mediation. Then they would have go for next further stage. What is the purpose for us to delay? It is between the consent from both the parties only. It has been posted for the mediation. If yesterday their advocate in original suit, if their advocate and the party has objected, no, we don't want the mediation.
Original suit is what?
That not to alienate the property.
That
See,
they will be deciding.
thing
it.
is, my lord-
We will decide this writ petition.
My lord, the thing is that the apartment purchased by me, the 3 BHK apartment, she is staying happily. I am in the roads, in the sense,
She has
I
also
am in
paid-
a rental house.
Now, if you cooperate with the court and argue the matter will be settled.
My lord-
And she is not ready to settle the matter. What is the purpose of mediation?
But they have only
It
taken
is not from
because
one day.
13th October
One
is the
party
mediation.
mediation will not be done.
My lord,
With the consent of one party, mediation will not happen.
yesterday only they have taken the date.
No, let them take, writ petition is only an interlocutory application. We'll decide it here. Yes. What is this order? 27, what is
My
the
lord,
order?
kindly refer to page number 142, my lord.
142.
142, my lord. The bank statement of the respondent, my lord.
No, I want to see the impugned order.
The impugned order was for 40,000, my lord.
Where is that?
Page number 49 to 62, my lord. On the page number 61 is the order, my lord.
Husband is hereby directed to pay rupees 40,000 per month. What is the wife?
Wife is currently yoga teacher, my lord, and she was not working for last 15 years before she started yoga. He is claiming
How
that
much she is earning?
maximum 6,000, 1,000 to 6,000, my lord. 1,000 to 6,000 per month she is able to earn because of the yoga.
Statement of assets and liabilities.
Yes, my lord.
According to the what is husband's income?
Husband income is, my lord, that is the puzzle, my lord.
Let's not go to the puzzles. Let's go to the evidence. Where is
As per his
the
bank statement, 190 to 167 is rotating.
one?
167 to 190 is fluctuating, my lord.
And any children in the wedlock?
One children is there, my
One
lord.
boy or a girl?
Boy, my lord.
Age?
14 years.
14 years. He's with the mother.
Yes, my lord. And husband is not paying anything for the fees.
When was the IA filed?
IA was filed in 2023, my lord. October 2023.
Yes. What is your submission?
My lord, my submission is that 40,000 was ordered by the family court to pay interim maintenance.
So school expenses of the child?
2 lakhs, my lord, per year.
2 lakh per annum. Yes.
My contention is that 40,000 was interim maintenance was ordered by the family court. 30,000, this honorable court has ordered to pay me 30,000 per month within fifth. That I am paying, my lord. The thing is, my wife is staying in my apartment. That is what earned by me, 3 BHK apartment. Now I am in a rental house. I have also filed my rental agreement in my petition. That is
Where are your
27.1.
expenses?
My lord.
Where are your expenses?
My lord, in the assets and liabilities I have mentioned, my lord.
Page number? Are they filed?
Yes, my lord. Assets and liabilities has been filed in my petition 27.1,
Take that also.
page number 68, my lord.
60?
68. Assets and liabilities I have filed, my lord.
Where are your expenditure? Page number?
My lord, page number 48, that I am paying a rental agreement of 30,000.
Not rental agreement, expenditure.
Yes, my lord.
Complete expenditure. Where did you stay?
Complete expenditures.
Page number, 40,000 per month.
Yes, my lord.
His expenditure is
40,000 per month.
40,000 per month. And any dispute about your income of 1,67,000?
No, my lord, I have already filed this one, that 1,67,000.
40,000 you're spending for yourself. 40,000 you're spending for yourself.
That I'm 30,000 is my rental agreement, and food and all etc. I'm spending it outside. And also my salary is fluctuating, my lord. My salary is fluctuating. That when I was in UK, my salary was this much, but when I came to India, it is fluctuating because of these 3 reasons. These are the 3 reasons my client has given.
What is the lowest?
My lord.
What is the lowest amount?
Yes.
1 lakh?
My lord, 1 lakh, he is getting now 1 lakh some, he told that 1,40,000, and the latest news is that he is getting, because of this layoff, his job is, he's losing his job.
He is not at lost.
Yes, not yet lost, my lord.
So we
The
will
thing
see
is,
when he lose the job, then we will see.
the thing is, what is the thing is, he is staying in the rental house. Now, whatever the 30,000 is paying.
Council, that is what I am clearly asking you. You said 30,000 is your rental, your rent you are paying. And what is the other expenditure?
Yes, my lord.
That is
I'm
why I'm
also
asking-
paying my age-old parents also for their medical
Show
expenses.
to the court from your statement.
Yes, my
I am
lord.
not able to see that.
If you take my assets and liabilities only, my lord, I have
Yes, it is
mentioned.
before me. Which page?
My lord, in last settlement, he's claimed that once he lose job, he will go to his parents. That parent, he will become dependent on parents. Now that
Lord, page number
dependents,
68,
parents are
my lord.
dependents.
Let him say, let him
My lord,
complete.
page number 68, my lord. 68, paragraph number 7, I have told that 30,000 per month is my expenses.
And your rent is another 30,000.
My lord?
Your rent is another 30,000.
No. 30,000 plus 20,000 food and maid services and all there. 40,000 it will come. Total 40,000 is spending on me, my lord.
Including the rent.
Latest rent is rental agreement is 30,000, my lord.
You decided not to answer to my question.
Yes, ma'am.
I said whatever the amount 40,000 you are saying, that is inclusive of the rent also.
Now it is 5,000 extra, 45,000. 30,000 rent, then 10,000 for maid and food services and all. I will go outside for the hotel for the dinner because I can't.
Let us say 50,000. What are you doing remaining 1 lakh?
Remaining my lord, 30,000 I'm paying every month.
To whom?
To my wife. My wife and children both 30,000 I'm paying, and also my age-old father and mother is there. I'm paying them also, my lord. 40,000, and also their medical expenses also I am taking care of that. The thing is, the only problem is, the thing is, if I am allowed to stay in my own apartment, then there is not an issue for me to pay the 30,000. The thing is, I am staying in outside in a rental
Also,
house.
you are left with a lot of money. Still, you are left with money. You say 40,000 your expenses.
Yes, my lord.
30,000 you are paying towards the maintenance. It comes to 70,000, and still you are left with another 70,000.
No, this 50 to 60,000 I'm paying to my father. They are age older. For medical expenses I'm paying them, and also that.
Pay 50 to 60,000 you can pay to your parents, but 40,000 what is granted by the court you are not able to pay to the son and the wife.
My lord, 40,000 was ordered, 30,000 I'm paying. The thing is, the only problem is that I'm staying in a rental house. If I'm allowed to be in my own house, then it's not an issue. I will pay 40,000 if that condition is met.
They will go out of the house. This 40,000 plus another 30,000 for their rent, we will enhance it. And you can stay in your apartment.
Because the apartment has been purchased by me with the loan. It fetches some 1 crore 70 lakhs odd, 3 BHK apartment. My wife and son is staying there. Every month I'm paying 30,000 to both of them. I'm the sufferer here as a husband, and also I have to pay the legal expenses. 7 cases are there. I have to pay my legal fees also. 7 cases are there, my lord. If you see, I have mentioned in my petition. One is
What are these 7 cases?
in 29th CJMM, there is 498 cases there. How to manage the legal fees? They have to pay the advocate fees also. 7 cases, one after the another, she is filing. I can't able to pay the fees also. And recently, what happened in the family court? After paying 30,000, it is meant for petitioner's evidence. Instead of doing the petitioner's evidence, they filed 91 application. By filing irrelevant application that what is my father property and my wife, my husband, sorry, my father, grandfather property in the Hyderabad and Telangana. What is the purpose? And we have filed the objection to the 91 application. Then the judge, that in their petition, they're taking contention that we are delaying 91 CRPC application.
If your client want to settle,
Yes, my lord. I'm ready to take my wife and children. But the thing is, here the thing is, they are not able to settle the matter. The wife is not able to come.
with this, whatever I'm asking, you are not understanding, and what your client understands and what settlement both of you will arrive at, I'm not able to understand. I'm asking, what are the terms of settlement for your client?
My lord, the thing is that he wants to take his wife and children
Not
back.
file even RCR.
He's ready to take back.
Threatening her.
He's ready to take back.
Completed. He sometimes is understanding the question. Yes. What is
But
that?
he's ready to take back his wife and children. But the thing is, see, earlier also they filed mutual divorce petition. It was the same advocate, same counsel. The thing is, they were not properly guided by him. It is because of him when he was
You
staying in the.
cannot say like that, counsel. How can you submit like that about
But the thing is, it's a minor dispute between the husband and the wife. It can be settled if it is posted for mediation.
MLC is
The thing
there.
is, the counsel is not rightly guiding her.
Joined the husband?
My lord, multiple
He had fractured my hand and leg several times.
2016 medical report, 2020 medical report, MLC in 2023.
So she doesn't want to come back. In that case, how your client want to settle it?
That's what they are asking, that 3 BHK apartment in Mahadevpura, that is 1 crore 90 lakhs, which is purchased by me with my own loan for 30 years. It's my dream. Then she's asking 1 crore cash, then leave the son, 14 years son. As a husband, if I give my 3 BHK apartment, 30 years I paid the home loan, EMI, everything, leave that 2 crore apartment, leave the wife, leave the children also, then what will the husband will get? I'm telling that I want my wife and children back. I want to lead a happy family, but she is asking, demanding, her demand is more. She's demanding more, my lord. She's asking 1 crore hard cash and also 3 BHK apartment and also leave the child. This is what the difference where I'm stuck is.
This is what has been signed by his
It is a bargainable amount, my lord. I'm ready to
mutual.
pay. If it is a bargainable amount, I'm ready to pay. You only tell, my lord, the 2 crore apartment, 30 years I paid EMI. Wife, children, 14 years. My kid is 14 years. Because of this, he is not able to go to the school. His education, his career is spoiled. Because of my child, I'm ready to take her back, both the child and the wife.
But he's not
his
ready to
counsel
pay
is
fees.
not properly guiding her.
Complete. Yes.
Our counsel is not properly guiding her, my lord. We have to set an example in a society. By this time, if both of them take the divorce, what will happen to my son's future? I'm worried about my son's future and also my wife also, both. But the thing is, what she's asking is arbitrary and it is not practical. You ask practical amount, I'm ready to pay. Practically,
What the amount according to you is practical?
Practically, my lord, the thing is that I have to discuss with my client. The thing is, she's asking 1 crore cash.
Ask your client.
Yes.
Ask your client and tell the court.
Date may be given, my lord, a short date. A short date.
Tomorrow. Come back.
My lord, interim order may be extended in the second.
Interim order extended, list the matter tomorrow. Tell your client.
Yes, my lord.
She is not interested to join back, join the husband. So what is his terms of settlement for all this? No, you are saying what she wants.
Yes, my lord.
Let your client also come
My
out
lord,
and say what he wants.
If you give after 1 week, I will keep him present only. You can directly ask him what he can pay.
Let both the
1 week.
parties,
Yes.
let both the parties come before the court on 10th September, 5 o'clock.
Obliged, ma'am. Much obliged, my lord.
Yes.
Lodge, one indulgence.
Serial number 28.
Serial number 25. The mediation date is not on 18, my lords. It's on 6/9.
Huh?
My lords recorded the order, my lord. My submission. The mediation date is not 18th of September. It is 6th of September.
6th of September.
Serial number 25.
Yes. Mediation date. Yes, next.
28, I am appealing for the petitioner, my lord.
Appearing for respondent, my lord.
Just told us like received a statement of objections filed with the respondent, my lord. I have for 1 week time to address my arguments.
Nothing is there to, we will only look at the interim order, the impugned order. Give the file.
But just at least tomorrow, ma'am.
Why?
Just yesterday I received the statement of objection. For that reason only.
But I am not looking at a statement of objections at all.
No, my lord, in this case, my lord, they are filing some statement of account. I am not challenging the interim order, my lord. I am challenging only the EMI amount that has to be paid by both the husband and wife. To that extent only the present writ petition is fine.
To that extent only we'll look at.
I have to verify the statement of account.
Because for a writ petition, it doesn't take 2 minutes.
I have to verify the statement of account.
List this matter on 9th. No further adjournments. Interim order earlier granted is extended till then.
Lord, interim order is not granted yet.
Interim order is not there.
Then list the matter on the day.
Serial number 20. On 9th, no? 9. Serial number 29. Shankarappa.
Your Honor, discussion is on for settlement, Your Honor. Kindly give us more time. They've been saying that they'll pay, but till now no payment has come.
In all the cases, settlement will go on either only with the husband or only with the wife, but not both wife and husband.
My only submission is the stay may be vacated, Lordship, because the stay was granted on the condition that the maintenance would be paid, but they haven't paid. Nothing has been paid till now.
Let's see. To 8/4/20. Land Council for the respondent submits that the interim order dated 8/4/2025 is not complied with. This is matter on 9th of September. By the time if the interim order is not complied with, the stay granted by this court stands vacated automatically without further reference to the court.
Hello.
Serial number 30. Sridhara.
For the petitioner, kindly
for
requesting
respondent.
time, Your Lordship.
On the
Senior
last date of
advocate is
hearing,
out
court
of-
has directed to produce the document pertaining to the child education and medical report, Your Honor. I am producing this. Copy is already served on them.
File before the registry. It is submitted that as per the order dated 4/7/2025, the land council respondent will file the documents today, and a copy of it is served on the counsel for the petitioner. This is matter on 22nd. Yes.
Serial number 31.
Much obliged.
But I appear for the petitioner.
Yes.
In this case.
Yes.
Lord, there are some papers that are to be filed by the respondent showing the sums of money that he has passed over to the petitioner herein and monies that have been paid on the account of the children. A short accommodation may kindly be granted. I will furnish.
To hear him?
Very well, my lord. Yeah. Short date may be given because he's not paying the educational expenses of the children.
Pardon?
He's not paying the education, you are not paying the educational expense.
No, sums of money in excess of the education have been paid.
List this matter on 19th at the
Obliged.
request of land council for the respondent. Yes, next.
Serial number 32. Rohita Shah Bhanswar.
32, yes.
For the
Manjunath V.
respondent.
For the petitioner.
Yes. Where is impugned order?
Last occasion, my lords had directed the registry to place the
pendency report of the trial.
What is the order that is sought for?
Please, in this
Madam
case, my lords, I have filed application under Order 18, Rule 17, and also under Section 151 for recall and for cross of further cross examination of the petitioner, the respondent herein. That came to be dismissed.
Where is that page number?
28. Madam.
28, it comments, my lord. May I read, my lord?
Registry directed to obtain information with regard to the pendency of third edition senior civil. Where is that? Oh, here, it is here. Which year is this petition?
21. Madam.
Twenty?
21.
There are several matters pending. 455 of 2016, 2017 117, 2018 121, 2019 167. There's a lot of pendency. In the year 2021 itself, there are about 205 cases. Several cases are pending. We can't give any order. Yes. So, in spite of giving repeated opportunity, why you
Yes,
have not
Third
crossed?
time.
Lords,
Third time.
lords, the petitioner herein resides at Bihar, my lords. As my lords, she had threat from the husband. Because of that, she has not come to Bangalore very recently. Because, my lords, that has been happened.
Lord,
Lords, in application, my lords, I have
not
not. One-
Not at all, my lord. They
This
have
year-
only communicated.
Huh?
Lord, these submissions are never made before the trial court. They have already commenced the cross examination. Post, they have filed an acknowledgement issued by the jurisdictional police. Post that also, they have commenced the cross examination. There, they have nowhere made a submission before the trial court. This is just deviating. Lord, if may permit to take to the order sheet, Lord. They have whenever the matter is posted to the arguments of respondent, only then, until then, neither the Lord, page number 14, my lord. Page number 14, order sheet, my lord. Lord, 8/3/2022, my lord. Lord, Wakalit is filed on 8/3/2022. Thereafter, my lord.
8/3/2022.
Yes, my lord. 8/3/2022, Wakalit is filed. Thereafter, matter was referred for mediation. They did not bother the matter was there before the mediation for 4 months. They did not bother to appear there. Then next one from here, Lord, 27/2022, respondent absent, counsel absent.
20?
Next, 27/2022. There, my lord,
Page
respondent
number?
absent.
Page number?
Page number 16, my lord. respondent absent, counsel absent. Next, my lord, again respondent absent, counsel absent. Again, no representation. Lord, then again next, my lord, 21/5/2023, respondent absent, counsel absent. Respondent absent. Next, 22/2/23, respondent absent, counsel absent. Then again, my lord, petitioner is examined. Next, 5/4/2023, respondent absent, counsel absent. Then again, my lord, MC, then again on 13/4/2023, respondent absent, counsel absent. Then again, my lord, till then no representation at all, my lord. Then finally, after some 15 adjournments, my lord, 30/10/2023, then when the matter is posted for respondent arguments, I have concluded my arguments. After that respondent order, then they'll come up before the court, then they file objections to the main petition, then they bring back the case.
27/9/2023, PW1 present.
I let my
Opponent has not filed the objection.
Yes.
Hence, there is no question of cross-examination of PW1.
Then further, my lord, on 2/12/2023.
For arguments by 30/10/2023.
Yes, yes. Then next date, my lord, 2/12/2023. Whenever it is posted for final arguments, only then they appear. 2/12/2023.
IA to recall and reopen.
Yes.
That's on 2/12/23.
That
A is allowed on cost.
Lord, 2,000 rupees cost. In total, once 2,000 rupees cost was levied, later for the second application 5,000 and the third application 500. Total 7,500 rupees cost is due. Even to this day they have not paid. Then, my lord, after this, again opportunity was granted. Objections were taken on record and cross-examination permission was granted. Then again, my lord, they made a submission and the matter was referred for mediation. There also she did not bother to appear before the mediator. Then next, my lord, 6/6/2024, advocate for petitioner present, submit, then represent, no respondent, no representation.
Not a case where court has to exercise any discretion.
Yes, my lord.
Why did you not pay the cost?
He is residing at
So,
Bihar now.
Let her reside there.
No,
Let
no,
her
my lords,
not
because
come.
my lords, he has thrown out of the house, my lords. My lords,
Those are
because of
not
that,
the-
my lords,
It is my house.
residing it. My lords, may make one submission. Last opportunity may be granted, my lords, and my lords, directing the
Last
last opportunity, my lords, I'll my
The already court had granted the 3 times on
Yes,
cost.
my lord.
You don't pay the cost.
Yes.
You don't appear before the court.
fix
Why
a
should-
shortest.
No, why should the court? There should be some reason. What did you say? What is the reason for you not appearing before the court on all these occasions? Let's see your affidavit.
Even in the affidavit, nothing
In
is
the
mentioned.
affidavit, my lords,
Nothing they have mentioned.
Then will
Lord,
not.
kindly see the
May make
affidavit, my lord, at page number 60.
Please come.
Sorry, my lord, page number 57.
Now, non-application.
Page number 57, my lord. First paragraph is that fully conversant with the facts of the
Agreed with the order passed on 18/2/2025 in MC number 464 by 2021, whereby the court had dismissed the, no, where is impugned order?
My lord,
Impugned order.
impugned order is at page
28 and 29, my lord.
28 and 29.
Court had dismissed the IA number 6 filed by the respondent. The court has observed that
4 and 5, 4 to 6, my lord.
No, 6 is
Maintenance. 6 is for maintenance, my lord.
IA number 4, 5
And
and
five.
6. The court has passed an order observing that the court has heard the counsels on IA number 4 to 6. IA number 4 and 5 are filed under order 18 rule 17 CPC under section 151 CPC to recall PW1 for further cross-examination. And IA number 6 is filed under section 24 of the Hindu Marriage Act seeking interim maintenance. The court has observed that several adjournments were taken for further cross-examination and it is rejected ultimately and further cross-examination taken as well. Applications are filed when the case is posted for arguments. When the court inclined to provide another opportunity, counsel again praised time. The senior has gone to attend another court. Hence, the court felt that I number 4 and 5 are filed without genuine intention and to track the proceeding. Hence, I number 4 and 5 are rejected. Then I number 6 was
For
posted
maintenance.
for-
Minutes, that is.
That is
Six
for
is
maintenance.
for maintenance. Minutes. That has not,
Six
I have
is-
not challenged that one.
challenge it.
They have not
So the
challenged.
present
Four and
reclamation is
five.
filed, questioning IA number 4 and 6.
4
which
and
are-
5, my lord.
4 and
Five.
4 and 5 filed under Order 18, Rule 17 CPC and Section 151 CPC. The land counsel for the petitioner submits that the wife is staying in Bihar, and because there is a threat to her life, several times she has not appeared before the court, and if the case is not recalled and an opportunity is not granted to cross-examine PW1, it would cause a lot of hardship to the respondent, hardship to the wife. When counsel appearing with the respondent husband has drawn the attention of the court to the orders right from 2022 and on how many occasions the wife was absent and on how many occasions the court had granted the permission to cross-examine PW1 on payment of costs. It is submitted that in spite of an order passed by the court by imposing costs, the costs are not, neither the costs are paid nor she has proceeded with the cross-examination. Whenever the matter is posted for argument, the wife is coming up with this application. It is a clear intention of the wife to drag on the proceedings, and the court had rightly considered and dismissed the application. Next part.
One date may be fixed. Minutes, so as
no,
because minutes, multiplicity of
I just want
minutes,
only,
I have not,
I just want
minutes, I have not
only
read
one,
any evidence here.
only one reason. 3 times,
Minutes,
5,000
minutes,
once,
genuine
200.
reason is that minutes, counsel father minutes, minutes, cardiac arrest has been happened. Because of that, he was
No, my
not
lord,
present
no,
on that.
no, my lord, not at all.
3 times.
No, my lord, no, my lord. No, from past
in the earlier occasion, it is not.
5,000, 250.
2,500.
I'll instruct my
Not at all,
colleague
my
minutes, who
Lord,
appears
my-
minutes before trial court.
Lord,
I'll intimate
the
him to
petitioner
prepare
also-
his own packet.
Not
minutes.
about payment of costs. In
That's
spite
one
of an
last
order on,
opportunity,
no,
minutes.
They're not
Yes,
challenging the,
minutes.
my lord,
that kind of indulgence
they're
is
not-
not
What has happened?
they have not challenged the petition, my lord. They have not challenged in the statement
I
to
have
main
not
objection.
read the evidence
They have
here.
not challenged my petition.
That's only minutes.
They have only asked for counterclaim with respect to maintenance, my lords.
Minutes. My brother has minutes. The respondent hearing has led evidence. Minutes. I had to have cross-examined in the earliest occasion, but I have not. Minutes, because minutes, at the stage of further evidence, minutes, further cross-examination, I have not. Minutes, before my last trial court, so I had to cross-examine. Because of that, minutes, it has application came to be rejected and posted for the final argument. Minutes, I have not led evidence. Minutes. If it is from
Why are you abusing the process?
No,
Why are you abusing the
because
court's time?
Annexure D may kindly be seen.
Not the annexure, not Annexure D.
Annexure
From your
D.
affidavit, tell the court why after
Minutes,
imposing
in the affidavit,
7,500
my
costs.
colleagues, because of my father actually admitted to the hospital, I was not present.
That you cannot tell. You have to tell it. Your affidavit should speak.
Affidavit clearly not speaks. But annexure D ink page 55. There is
is
a
there in
threat. There was a threat.
So
Because
then how can you
one
pursue
date,
now?
one
If
shortest
there
date.
is threat to you, how can you pursue the matter
By
now?
next week, Monday,
How can be? Your threat still persists.
by Monday, I'll cross examination put in toto,
Not grant, will
and
not
thereafter any date,
not permit the
within 1
parties.
month, I'll
Could have-
complete the trial and also.
50,000 costs, I will allow. I'll allow with 50,000 costs.
She is without maintenance, she has been thrown out from the house. She is living at matrimonial house,
What
Bihar.
referendum? Have a,
Please wait.
10,000, cost, please.
Already
Because-
7,500 is due.
Plus,
Already 7,500 is due before the court.
I'll
10,000
including
is,
that,
It is not, it is not.
excluding that, 10,000 it may be. Please, because my lord, she my lord, without any
If
my lord,
somebody is
maintain.
playing with the courts, with the time, with all these tactics, they should pay
I
that.
understand, my
They
lord,
should
but
pay
my
the
lord,
cost for that.
it is due to my lord, my colleague who appears before the trial court whose father my lord,
Forget about it. Forget about the colleague. Don't blame anybody.
10,000 cost.
No. 25,000.
Lords, my,
Get instructions or else I'll not.
the
My
respondent,
lord, kindly make it 15,000, my lord, please.
respondent has
Again,
already,
My lord.
20, first of all,
Because my lord, she is wife, my lord, she is not with any employment, my
if
lord, she has to
husband,
get the.
she has a gas
for
agency,
the
my lord.
court, both are, why are you are submitting when the court is with you?
Please, please.
At least that you should understand, isn't it?
Please. Please.
What did you write? Application. This court has perused. No, that is a submission. Submission. This submission. Submit and there are no grounds to interfere. It is only the delaying tactics. Next paragraph. This court has perused the order sheet right from the inception, as rightly submitted by the learned counsel for the respondent. On so many occasions, there was no representation. And in spite of the indulgence by the court, by granting repeated opportunities to cross-examine PW1, the wife has not proceeded with the matter, and time and again, court had imposed costs on four occasions, which is around 7,500. Learned counsel appearing for the respondent submits that the petitioner, the wife, had not even paid those paid the costs, nor she has questioned the said order. The it is a submission of the counsel for the petitioner wife that she is residing in Bihar, and there is a threat to the life of the wife. As such, she could not proceed with the cross-examination. He submits that if a date is given, on the day she will complete the cross-examination. This submission of the petitioner has no legs to stand. If the threat is persisting from 2022 and he is not able to proceed with the matter, how he will be proceeding with the matter on next date of hearing. Even the affidavit that is filed before this court, when there are so many latches on the part of the wife, at least the petitioner should have been diligent in filing an affidavit which discloses the proper reasons for not appearing before the court. This court initially inclined to dismiss the petition. Also considering the fact that if the wife does not get an opportunity to cross-examine the husband, then it would cause a lot of prejudice to her. Hence, balancing the interest of both the parties, the order impugned is set aside. That is, order in I number 4 and 5 is set aside, and the petitioner shall cross-examine the respondent husband on 22nd of September. 22nd. On 22nd of one day is sufficient.
1 day is sufficient. They
On 22nd
already
of
partly cross-examined.
September, only on the condition that she should pay 25,000 costs to the husband, and also along with that, the earlier costs of whatever the earlier pending costs shall be paid.
Yes.
Only on payment of this, she would be permitted to cross-examine the husband on 22nd, or else the order impugned will be enforced. Yes.
Including 7.5,000.
Huh?
25,000 left.
No. First of all, if you ask one more, I'll dismiss the petition itself.
Public.
Yes.
33,
Yes.
Mahin, Chandra, for petitioner,
Here for the respondent, my lord, I may permitted to file the objection, could not able to do it in earlier occasion.
What objections you want to file?
On the file, my lord, the trial court has granted 10,000 rupees maintenance. Now she is in a rented house. Within 15 days from the date of marriage, he left the respondent. And also the parents of the respondent.
Oh, whatever it is there, that is there before the trial court, every material is there. What is the new facts now?
New facts is there, but he has suppressed certain facts, my lord. I want to bring it to notice.
That you should have brought it before the trial court, not
Please.
before this court.
No.
I am only concerned with
Regarding
order,
my humble,
impugned order, nothing else.
my humble request is, it is granted by the trial court 10,000 rupees. The rented premises 5,500.
Have you filed any writ petition?
Please, ma'am.
Have you filed any writ petition?
No, ma'am.
You're a respondent.
No, I am for the respondent. The petitioner has filed. Husband
So
has.
there is nothing for enhancement in this. Give the file. We'll only consider whether the order is right or not. Yes, where is impugned order?
At Annexure G, my lord. Annexure G, page 51.
Page
Sorry,
number
my lord.
54, my lords.
54.
Impugned order. The reasoning starts, my lords, at page number 62. Lords,
10,000 is granted.
10,000 is granted.
What is your
paras
income?
17 and 18.
What is your income? What is your income?
Lords, I am an agriculturist and I don't have a fixed income, lords. It depends if.
What did you say before the court in the statement of assets and liabilities?
Yes,
But in the
40,000 rupees according to their own statement, and also he is owning agricultural land.
Him say
I'm
because he is
sorry.
a petitioner.
I'm sorry, ma'am.
Yes.
Lords, in my statement of assets and liabilities, my lords, I have stated that the general expenses is 15,000. That includes my loans and everything, my lords. I have an age-old mother who is suffering
So
from.
your income is 40,000 according to you.
Not 40,000, my lords. 15,000, 1/5. My
He's saying 40,000. Where
No,
from you say that?
They, my
It
lords,
is there-
I am
it is there
permitted
in
to
the,
submit. They say that
liability,
I'm working
my
in a milk dairy.
Not they say, what you say. Where are your statement?
He is
of
a president of the
47, my
milk
lords.
dairy, and also he
Page
is vending
40.
milk, my lord. He is having 5 cows. Each and every month they are receiving 13,000 rupees per month. And he has managed to delete his name from the milk where he is supplying the milk of 5
Was
cows.
in the year
And
2023, before
the
I
name
got
is
married,
deleted purposely in order to produce
had
the
to
copy.
Sell my cows for the reason that I have to pay them. I have to pay their house which they are living. That is
Totally-
leased out
totally
in my
incorrect.
money. She is living in Mysore. She want another house to live. She want me to shift from my village to the city. And my lords, your lordship may kindly see their own petition. They say that the petitioner assured the respondent that he would he would make a house in the city. That's why she got married to me. And in the same petition, they say that the petitioner has persuaded the mother of the respondent to.
That's not the scope of this writ petition.
Kindly, my lords.
Only with regard to your income. In
Lords.
your statement of assets and liabilities, what did you say?
Lords, my expenses are 15,000, which is including my mother's.
That's your expenses, your income is 15,000.
Lords, my income, lords, I would fairly submit, my lords. I cannot determine how much I would get, my lords, for the reason, if at all the good crop is there, I would get a better income. If the crop is failed, my lords.
So if it is a bad crop, there is some amount. If it is a good crop, there is some amount.
Yes, my
What
lords.
is that?
My lords, that I have to seek instruction like what is growing and.
Please get instructions.
Kindly, my lords. Interim order may kindly be extended.
This is matter on 11th of September.
My lords.
Interim order earlier granted.
12th, my lords. Not on 11th, my lords. 12th.
Huh?
12th, my lords.
12th.
Kindly. Interim order may kindly be extended.
Interim order is complied with?
Lords, 75,000 has been paid. 5 more days is left with me. On 6, my lords, they have
No,
post.
by the next date of hearing.
By
the
6th,
interim
my
order
lords.
is not complied with. The
10,000 more has to be
The stay
paid.
will be vacated, whatever it is.
10,000 more has to be paid.
Whatever it is.
Kindly.
Yes. The next. No, last matter. This is the one.
34.
Who is adjourned? Yes.
My lord, may I make a submission, my lord? Serial number 8, the petition may be dismissed, my lord. We didn't receive any instruction.
After lunch, I'll do it.
Serial number 15 in the list number 2, Malay.
No adjournments.
Not that, Malay. Myself and my learner friend is also here. We request your lordship to kindly refer it to mediation.
List.
Serial number 15 in the list number 2, Malay.
Serial number 15 in list number
2. RPFC 187 of 2025.
No adjournments, only if any these kind, then only please make a mention. Should both the parties submits that. 15 is RP,
Please,
RPFC?
RPFC. RPFC.
Oh, that is third list. No, second list.
Second list, madam.
1 minute. No, that's what I said. Because these matters are noted. Is it? Both the parties submitted, which Bangalore or?
Bangalore mediation.
Both the parties submitted the matter may be referred to the mediation. The party shall appear before the mediation center, Bangalore on 12th. Please. On 12th September.
My lord, serial number 16, 1 week's time may be granted.
No adjournments now.
My lord, still notice was not issued. For stay.
That's why we will hear it. If it is a matter for stay, we'll stay, or else we will issue notice.
1 week time may be granted.
After filing a petition, you see time. I don't understand this.
3 o'clock, final hearing
matter
matter is
on
there.
in the month of October, October 13th.
List number 3, serial number 14 time ತಾಂಡಿದಾರ. Time ತಾಂಡಿದಾರ. Time ಬೆಳಿಗ್ಗೆ time ಲಾತೂರು. ತಾಂಡಿಲ್ವಾ?
ಯಾವ ಲಿಸ್ಟ್ ಸರ್? ಅಲ್ಲ ಸರ್, ಯಾವ ಲಿಸ್ಟ್ ಸರ್? ಎರಡನೇ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಎಂತ? ಡೇಟ್ ಹೋಗಿದೆ ಸರ್. ನಿಮ್ಗೆ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ದೀರಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ ಅವರು. ಗೊತ್ತಿಲ್ಲ ಅವರು
ಕೋರ್ಟ್ ಆಫ್ ಸರ್, ಮೇಡಮ್ ಕೋರ್ಟ್ ಆಫ್ ಸರ್.
ಸರ್ ಕೇಳುತ್ತೆ ಹೇಳಿ ಸರ್.
ಮೇಡಮ್ ನಾಗರಾಜ್ ಅಡ್ವೊಕೇಟ್ ಮಾತಾಡ್ತಾ ಇರೋದು. ಲಿಸ್ಟ್ ನಂಬರ್ 3 ಏನಾಯ್ತಮ್ಮ?
ಲಿಸ್ಟ್ ನಂಬರ್ 3 ಕಾಲ್ಔಟ್ ಆಗಿಲ್ಲ, ಕಾಲ್ಔಟ್ ಆಗುತ್ತೆ ಸರ್.
ಆಗತ್ತಮ್ಮ, ಸರಿ ಅಮ್ಮ, ಓಕೆ.
All the password.
Yes, sir. For being spoken to. Yes, I Rajendra.
Yes. There is order. Yes.
My lords, in writ petition number 21516, my lords,
Hmm.
I have challenged the defense strike of order, my lords. Without considering the merits of the matter, my lords, your lordship has fixed a date for December 15th, my lords, for the MC petition. However, the trial court is not considering that aspect, my lords. They are not allowing to contest me, my lords. Since explicitly the defense strike of setting aside order is not mentioned in the order, my lords. Seeking clarification on that aspect.
Where did you argue?
Please, my lords.
Where did you argue that?
before the trial court, my lords.
Is filed, agreed with the order passed in so and so. Bangalore had failed to pay the maintenance. The family could allow the IF filed under so and so. Order is passed by the coordinate bench of this court, subject to the conditions the petitioner husband. Then when I'm passing this order,
Please, my lords.
is it not for you to bring it to the notice of the court? Because it is a old matter, I've directed them to dispose of, and order is passed in the court. I said I'll not consider any of it on the merits of it.
Please, my lords.
Then we should have, where is the respondent?
My lords, even in the last date of hearing, my lords, the respondent submitted that they don't have any objection to setting aside that strike off, my lords. Payment has been made, my lords. Even that is mentioned in the paragraph number 5, my lords.
The matter is placed before this court and the caption for being spoken to. 2 writ petitions were filed by the wife, one by the wife and one by the husband. Husband is before this court, agreed by an order passed in I number 9, where the defense of the party, there's an order of striking of the defense of the husband. This court, considering this, both the writ petitions, one by the husband, other by the wife, has disposed of on 17th July 2025. Observing that main MC is filed 10 years, is an old MC, which is more than 10 years. Hence, the court feels no further orders needs to be passed in the writ petition, and a timeline shall be fixed to dispose of the main MC, where all the disputes between the parties can be decided. Accordingly, this court had directed the Principal Judge, Family Court, Bangalore, to dispose of the MC 4610 of 2015. Then counsel submits that as there is no order setting aside the order passed in I number 9, the family court is not permitting the husband to proceed with the matter. Considering all this, in view of the same, the operative portion of the order, in the operative of the order, this shall be reflected. The IA number 9 passed in MC number 4610 of 2025 is dated 9/11/2021 is set aside.
Much obliged.
Much obliged.
Pass over matters. List number 1, CL number 8. Arun Bhaiya.
So,
Yes, ma'am.
shall I pass an order on the merits of it, or that you don't have instructions on the merits of it?
My lord, our only contention was that without any documents produced to show any salary, my lord, the court has passed an interim maintenance of 5,000 rupees, my lord.
That's what I say. That's
Yes.
what is your contention.
Yes, ma'am.
When this court has specifically asked what is the income of the husband, for your instructions, the matter is adjourned. Again, the matter is called today, again adjourned, but still he is not giving any instruction.
Yes, ma'am.
In that view of the matter, we would not see anything to interfere. Where is the impugned order? So, agreed with
Next
the order
schedule.
passed in I number 1 in criminal miscellaneous number 109 of 24 dated 17/4/25, whereby the court had granted 5,000 as maintenance to the wife. The husband is before this court. When the matter came up for admission, This court has specifically asked when it is contended that without looking at the income of the husband, the court had granted 5,000. This court has specifically asked what is the income of the husband. Then counsel with the petitioner sought time to get instructions. Today, when the matter came up in the morning, it is submitted that he was not, either the client has not given any instructions. Again, the matter is passed over. Even in the afternoon also, it is submitted that no such instructions are given by the petitioner. It appears that the petitioner do not want to state the correct facts before the court. And in that case, and the maintenance amount that is granted is only 5,000, and this court finds no reasons to interfere. Accordingly dismissed.
Obliged.
Bill number 13. Rashid Khan.
Let's see another court arguing some parted matter.
MD.
Have it next week.
You are for the petitioner.
I am.
At the request of learned counsel, the respondent, list this matter on 23rd of September. Yes.
List number 2. 23rd of September, sir.
Date may kindly be.
23rd.
Great.
List number 2, parted matter, seal number 1, Madhukar Deshpande.
I appear for the petitioner, my lords. I may be allowed to make my submission. I'm a partially handicapped woman, my lords. I'm a partially handicapped woman. I was driven out of my house, marital home, on 5/7/2014.
Where is the impugned order? Impugned order. Page number.
Page,
Let him say. Yes.
page number 14, my lords.
Petition is dismissed.
Please, my lords.
Where is paragraph number 18? 30.
I may be allowed to make my submission.
I'm just
right?
asking him where is paragraph number he was referring to.
Page number 22, my lords.
Yes.
PW1 in her cross-examination has clearly stated that she is graduate. The respondent has studied up to 10th standard. PW1 has clearly stated that if she tries for the job, she will get job. But so far, she has not tried for the same. When it is suggested to PW1 that there is no problem for her to go for job, she replied that she will not go for job, from which it is clear that the petitioner is capable of earning her livelihood. In fact, the petitioner has shown her liability of maintaining her two minor children. So the petitioner is not entitled for maintenance. Hence, I answer point in negative.
What is this? The petitioner has shut her liability of maintaining a two minor children or also the husband.
I am driven out of my marital home. After what the court observes, because my mother was informed before I was driven out of the home, it is justified. The act of the husband is justified. And then, what the trial court judge observes that because I was browsing internet, the act of petitioner, act of the husband to throw me out of the marital home is
All those
justified.
things we will not go into. Only you tell
No,
the
my
court
lords, I understand to come to explain why I have admitted this particular fact. I'm not in a position, mental position or emotional stability to go and work. For 10 years after marriage, I have not been able to work. I was with my husband, and all of a sudden he throws me out of the family, and the court says that because you are able to work, you are not working, you do not deserve any maintenance. This is one of the observation, but the rest of the observation
not required. All those observations we don't have to look into.
I rely on Malak's. Para 5 of the order, Malaks. The Supreme Court in Shailaja versus Kobana, Malaks, in para 5. That apart.
Say that this is the precedent. Where is the, what is the discussion? What is the ratio?
Please, Malaks.
What is the discussion? What is the ratio laid down? You cannot say that this is a judgment.
Which one?
This is reported judgment, my lords.
But what is there? Nothing.
Well, as next page, para 5.
I've seen, if you say that a particular judgment is binding on this court, there should be an issue, there's something should have been decided, the court should have laid some proposition in that, then I can say that it is, the court. will
Unless
look
what the
into it.
trial court has observed, my lords, from which it is clear that petitioner is capable of earning her livelihood. May I allow, my lords, if that apart, we find that High Court has proceeded on the basis that appellant 1 was capable of earning, and that is one of the reasons for reducing the maintenance granted to her by the family court. Whether appellant 1 is capable of earning or whether she is actually earning are two different requirements. Merely because appellant 1 is capable of earning is not, in our opinion, sufficient reason to reduce the maintenance awarded by the family court. In my case, my lords, I was not at all even awarded anything. Well, that I am a partially handicapped woman. None of these things were considered. And my lords, he has filed a divorce petition against me. I am trying my every possible way to save my marriage. I have filed restitution of conjugal rights. Despite all of these things, my lords, I'm not an economic product that today somebody will throw me out of the family and tells me to go and work.
Yes.
I must also be in a position to earn. It's not just about the money, my lord. It's about also my dignity. Somebody decides that I'm not allowed to, I need not to be continued as a wife, and she throws me out of the family.
Yes.
On the first name of his argument, she is not working. But I can put it on record, my lord, presently she is working at the Samsung Service Center, Tulpur. I can provide the details. Your lordship may summon her employment ID from the employer. Because the petitioner is being brought on the court, presently she is working, my lord. She is working presently. I can provide the details, my lord.
Please come. Then counsel the respondent wife's husband submits that. Presently, she is working in a Samsung service center. Huh?
I do not have any instructions with regard to this, my lords.
Please wait.
She is working in Antika Services Center, which takes care of sunset services.
Write on a paper. Then
Yes,
counsel
even
the petitioner
may I
submits
make
that.
one submission?
Just wait what the court is going to tell.
Please.
Just wait what is the order
Please.
of the court. Then counsel the respondent submits that the wife is working in so and so, and the said fact is suppressed before this court. Then counsel for the petitioner wife submits that he'll get instructions in this regard. The wife shall file an affidavit before this court whether she is working or not. If she is working, from when she is working, where she is working, and what is her income. This is matter on 25th of September.
Tell number 2. Tell number 2. Anman Kayappa K for petitioner Manjunath BR.
Where is the counsel? Last time also not there.
Last time he was present, notice was issued to me, my lord. I have filed power for the respondent.
Huh?
Last time notice was issued to me, now, my lord, I have filed power for the respondent.
Interim order is, what do you say about the delay of 481 days?
But no proper reason is assigned in the affidavit, my lord. If your lordships can peruse paragraph 5 of the affidavit accompanying the.
On behalf of the petitioner, this is matter for dismissal on 9th. Yes.
Tell number for dismissal matter. Tell number 3.
3, my lord, I beg to appear for petitioner, my lord.
Yes.
My lord, the case, my lord, husband and children have filed this petition claiming compensation, my lord. The trial court has awarded 10,000 to wife, my lord, 5,000 to children. My lord, before trial court, my lord, I am placed ex parte. I was not appeared before the court, my lord. My lord, the claim of the wife is, my lord, I am doing so and so work, my lord, but to substantiate the same, my lord, no records have been produced, my lord.
What is your income? You can tell the court.
My lord, actually, as per my lord, is doing the coolie work, my lord. You have no independent work, my lord. That's my submission. But as per present, my lord, I am not able to contact client, my petitioner, my lord, on categorical effort, my lord.
Why were you ex parte before the court?
My lord, to ascertain the same, my lord, court ordered to secure the record, my lord, record are before court, my lord.
Yes, show that. With regard to the notices on the respondent. Process from the beginning. When was the placed ex parte? Where is that order? Notice to respondent return. Something is there. Here. Left side. With the shara. Refused or what it is? Give it. Notice to respondent returned. It's not served. No case called out, petitioner absent, respondent absent. Respondent placed ex parte. For ex parte evidence, call on 6/7/19. Notice to respondent return. And then in spite of service of notice, respondent has not appeared. How it is served is not known. What is this? Hey, what happened? That is court summons served, I think. Yes. Master, something is there. Is the color? The color. Yeah.
Serial number 3.
Summons are served. Your signature is also there on the summons.
My lord, if one more opportunity give, my lord.
Why should we give one more opportunity?
My lord, before
There
my
should be
lord.
reason. First of
My
all, you
lord.
have come to the court saying that no summons were served on you when your signature is there affixed on the. That's what you were submitting. That's why we have called for the record. Summons are served on you. Same, your signature tallies from this to the wakalat also.
Appointed advocate also. Appointed also, advocate also appointed. Advocate was also appointed.
No,
Advocate
expert.
is
It's place expert, not advocate representative.
I think the advocate was not engaged.
I think
Advocate was not engaged. Yes, please come.
At least, my lord, some reduction in award to compensation to wife, my lord. Awarded 10,000, my lord. At least make it 5,000, my lord. Because I am doing coolie work, my lord.
the wife is illiterate. She has no other source of income.
Quoted granted.
She sought for 20,000.
Quoted granted 20,000.
Total 5,000 each to children.
We'll make it 15,000.
Children.
Good for you. If you want, no, even if I dismiss, then if this order is there, at least you'll pay and your client will get some relief.
But the petitioner not complied the order of the Supreme Court.
You can file your EP. You can file execution.
Yes.
Agreed with her.
But he has source of income. He is businessman.
But you have not filed any document.
No documents. I do agree.
Agreed with the award passed in. See miscellaneous number 626 of 2018 dated 19th August 2019, whereby the court had passed an order granting maintenance of 10,000 to the wife and 5,000 each to both the children. The husband is before this court. When counsel appearing for the husband submits that no notice is served on him and he was placed ex parte. He is a coolie and without any material on record, the court had granted maintenance of an amount of rupees 20,000 and the petition is not in a position to pay the said amount. On the matter when the matter came up on the last occasion, it stated that no notice is served on him. Then this court has called for the entire record. As per the record, the summons was served on the petitioner. Hence, the said submission that no summons was served is without any basis. As rightly, the land counsel appearing for the respondent wife submits that he is having the income and assets, and the court had rightly granted 20,000, and the wife is not able to maintain herself and the two children. Hence, no grounds to interfere with the order. Next paragraph. Having heard the counsels on either side, there is some material on record. Though the court had granted the maintenance of 20,000, that is 10 to the wife and 5 each to the children, there is no evidence on record to show what is the income of the husband. In fact, this court was inclined to dismiss the petition as though notices were served on the petitioner, he has failed to appear before the court and came before this court with this RPFC which is filed in the year 2021. The order is passed on 19th August 2019. Considering all these aspects and balancing the interests of both the parties, this court deems it appropriate to pass a following order. The order impugned is the order dated so and so is modified, and the wife is entitled for this court is granting maintenance of 5,000 to the wife and 5,000 each to both the children, accordingly disposed of, accordingly partly allowed.
Much up.
Cell number 4, Mamata Shetty, for petitioner.
To the respondent.
Aditya Kulkarni.
My lord, the enhancement amount of 4,000 is granted by the court is
Or switch on the mic.
very meager.
There is no representation on behalf of the petitioner.
My lord,
The matter was directed to be listed today and the caption for dismissal. Today also there is no representation on behalf of the petitioner. Accordingly, dismissed for non-prosecution.
Cell number 5, Venkataramana.
When the matter came up on 29/8/2025, as there is no representation on behalf of the petitioner, the matter was directed to be listed today in the caption dismissal. Today also there is no representation. Accordingly, the petition is dismissed.
Cell
for
number 6,
non-prosecution.
Purushottam.
For petitioner, madam. Memo of calculation.
On the last occasion, I made my submission, my lord. The interim order granted by this honorable court,
It's not
that
complied.
it is only with regard to the directing him to pay out of 6,000 and 4,000, 3,000 and 2,000 respectively. But with regard to the areas, there is no specific order, my lord.
We'll
Therefore,
dispose it of.
please, my lord.
Argue.
Kindly, my lord, because earlier coordinate bench have been argued, my lord, for
We'll
the
decide the
reason.
main matter itself,
Yeah.
right to wait for the interim order.
Yes, ma'am.
Please come to the order. What is the order? That the 6,000,
And 4,000.
6,000
6,000 and 4,000 earlier trial court have been ordered, but
4,000 to the child comes to 10,000. What is your income?
coolie, my lord.
Huh?
I'm a coolie person, no income, assets and liabilities have not been disclosed in the trial court. Nothing is there. He is difficult earning. That too, these days, heavy rain is there in Chikmagalur. It is very difficult to get that. However, we have been complied the order, whatever the coordinate bench have been ordered, we have been complied, my lord, for the reason. 3,000 and 2,000 coordinate bench have been ordered. We have been
It
complied.
is in the order, my lord, it is, he is doing business. But with regard to that other things, my lord, that there are, but he was placed ex parte. He was not contested.
Why you are not contested?
No, my lord, because due to that, he been admitted to the hospital and the council and the petitioner. It is difficult to communicate with the things. Together with that, what he will do is in coffee estate, he is going to do the labor work, coolie work. For the reason he will shift into that side, he is not aware with that. He is very illiterate for the reason, my lord. However, he is complied with the order. Whatever the order been coordinate bench ordered, we've been complied.
So it is complied only for the payment of rupees 4 months. That I am not
Yes.
saying that I have not received.
They said 1
But
lakh.
the order is
What is paying now?
the
5,000.
20,000 rupees. Well, 5,000 rupees.
5,000.
That the order is from the date of petition.
We'll make it 8,000.
No, my lord, for the reason, my lord, that also very difficult. Because they have not at all been placed any record, my lord. They are saying that 1 lakh income per annum. How can we believe that they have not at all been placed
You
any
are
document?
paying, as per the order of the court, you are paying
5,000, my lord.
5,000.
Accordingly, I am following, my lord.
Another 3,000 you pay. Another 3,000.
No, my lord, for the reason, he is coolie, my lord. Now, that one, because of that reason, my lord, because of that reason, I submitted, my lord.
Income of the coolie.
No, my lord.
Getting
See,
something-
no, my lord. In a month, 1 week or 2 weeks, I will be getting the work. Or other days will not be. That too, these days, the heavy rain is there in Chikmagaluru. The reason is that you will not be getting any income. What we do, my lord? For the reason, however, we've been,
Complete in another 2 months, once the monsoon season is over.
no,
After that,
my lord, coolie work means in coffee estate, what they'll do is in a month, obviously they'll get it that one 10 days, 15 days like that, they'll get the work. Another 10, 15 days, they'll leave on that for the reason.
what are your
However,
occupation?
we've been complied.
What is his occupation? He is a coolie?
No, nothing being
According
placed
to
in
that,
front of the court, my lord.
the order, my lord, that I am not having a personal, but as per that, he is a businessman, that is the information I received. Then otherwise that I will get the information what he is doing.
And
Then
the
I will,
respondent also has got very good income, my
please.
lord, but they are not disclosing that also that I'll produce, my lord.
Your friend is having or the client is having?
No, my lord, the respondent.
Yes. Get instructions.
Please.
The land counsel respondent submits of the petition is doing business, and in that regard, he'll get specific instructions. This is matter on 25th of September.
Obliged.
Obliged.
Delete from the caption dismiss.
In the meantime, my lord, that for the arrears, the further amount, my lord, I have
I'm
already
following, my
furnished the account.
I am following.
No,
Furnished the
even
account.
if the order is, whatever is the order, you have to pay the arrears.
No, my lord, that in the order that we are getting also doubt, for the reason they submitted to the honorable court, let it clear with the things order. But
We'll
as
clarify
per,
that.
as per the order, we've been complied.
The-
Order is 3,000 and 2,000 it is there.
At 5,000, this court has passed an interim order directing the petitioner to pay 5,000, but there is no order pertaining to the arrears. The order dated so and so is modified, and the petitioner shall pay the arrears also at
My lord,
5,000.
kindly reduce with that then total bulk amount, my lord, for the reason because
No, we'll give you some time. 5,000
okay, together with that,
within a period of 10 weeks.
my lord, together with that, kindly reduce that to total bulk amount, my lord, for the reason because because
5,000 at 5,000, I'm saying.
in the ratio, but in the bulk amount, because we need to pay that bulk amount, my lord. Arrears means by we need to pay that bulk amount,
10,000
whatever it is.
No, part of the arrears, first part of the, half of the arrears shall be paid within 6 weeks, and remaining part of the arrears in another 6 weeks.
No, no,
from the date of
let him deposit to the account I have already furnished to him.
The
I'll-
same shall be
I'll
deposited
follow, my lord. I'll follow.
to the account of the wife, which
Oh,
the
bless.
particulars are already with the petitioner. Then in that case, what we do is list this matter on, in the month of November, we'll list.
Please, my lord.
List this matter on November 4th.
Obliged.
Obliged.
Cell number 7, hearing on interlocutory applications, Mohammed Selena.
Petitioner, my lord.
Notice,
My lord.
notice. Delay is there. We'll order notice. Issue emergent notice.
Condonation 87 days.
That's what notice has to go. We can't condone it.
Cell number,
Please.
Emergent notice.
cell
Yes,
number
right.
8, adjourned. Cell number 9. Cell number 9,
No representation. This is matter on 13th of November. Yes, 10.
cell number 10. Sudhakar.
In the
petitioner.
first matter, my lord, I am for respondent. In this 10.1, I am for petitioner.
In the second petition, I am for the petitioner. My only request is, I filed divorce petition, this was granted. Thereafter, she initiated 5 or 6 proceedings. I am ready to settle because permanent alimony is also not granted to her. I am ready to settle if it is set for mediation. 5, 6 proceedings she has initiated. Every day I am humiliating. I lost my parents also. I am the only son. She has not allowed me to see my son also.
No. He is already married. He is having the 2 sons. At the age about 11 years,
Ready to settle it.
the divorce petition has been dismissed last year, my lord.
Preparing for the petition submitted, the husband wants to settle this dispute as he's already remarried.
No, he is not married.
No, yes, my lord. He remarried. He having 2 sons,
Yes.
aged about 8 years and 9 years.
Dispute. Both the parties shall appear, where they stay? Bangalore or?
No, Bengaluru.
Both the parties shall appear before the Bangalore Mediation Center on
No.
23rd of September.
Short date may be kindly fixed.
23rd, short date, on 11th of September.
Yes.
Yes, next.
Cell number 11.
And so on submission, last occasion that order has been, it is again actually submitted by the petitioner, not my
What is that?
That order has been, retirement memo, the serial has been requested, now it is showing in
No, we will see
respect
next
of me,
Yes, yes, next.
in both the cases.
Yes.
Serial number 11. Syed Khalil Pasha.
Morning, he was asking that the matter should be referred to the mediation. You were not there. I said in your presence we'll do it. Is there any
Mediation.
scope for mediation? Settlement?
Mediation, right?
Where in Bangalore?
No, from Mangalore, yes. Sir.
The mediation center will be there, Bangalore.
Mangalore is there.
It is submitted that there is a likelihood of settlement. Both the parties shall appear before the Bangalore Mediation Center, Mangalore Mediation Center on 15th? 15th. Yes.
Mangalore, no?
Mangalore.
Mangalore.
Yes, next.
Serial number 12. Nagaraja KR. Krishnamu.
No representation. This is matter for dismissal on 16th of September.
Serial number 13.
Appealing for the petitioner, my lord.
Geeta Devi.
As your lordships are aware of the facts, my lord, on merits there is no any findings by the trial court for ordering 50,000 rupees of amount, my lord. The conclusion of the trial court, my lord, at page 25, my lord, internal page 12, my lord. Previously, the matter was listed before the chambers, my lord. Your lordship.
How much is the amount granted?
50,000, my lord, in total. 25,000 for the wife.
Oh, now I remember that case.
Please, my lord, please.
You are appearing for the husband.
Please, my lord.
Any interim order in this?
Please, my lord.
What was the interim order?
Stay of the
Take a complete
order
stay,
of the
no?
trial court, my lord.
No condition.
Condition was there, my lord. I was, to bona fide reason to show that fixed deposit in favor of the children's. That has been I have done, my lord. I have placed a memo on record.
No. Then what will they? How will they survive if it is in the?
But all are
fixed
residing together, my lord. Where? Please, please.
They are together, but they
Please,
have their
my
own
lord.
expenses.
All the expenses will be borne by me, my lord. They are not spending anything. That was my contention. That is the reason they stay.
No. Apart from that, they require some amount.
My lord, all the amounts it's in our account. Even that I have bought a record, my lord, to show.
No.
Even the
No,
groceries.
No. I'll make
Please.
it very clear. Now the child
Please, my lord.
who is suffering with autism.
Please.
Autism, he shall be immediately joined in the what is that called?
Preserve school.
Huh?
Persever school, my lord.
What is the spelling?
Preservance, preservance.
Preservance, my lord.
Preservance, preservance.
Preservance school, he shall be sent immediately.
Please, my
And
lord.
it should be reported to the court.
It's in my document 13, my lord, where I placed the.
And daughter's educational expenses has to be borne by him.
Please, my lord. Even the first year PUC amount has been paid. Only the second amount is 65,000 has to be paid within this year. Even that he has undertaken to pay it, my lord.
Some amount for her.
Lord, my submission before your lordship.
Show me what is there in her account. As on today, what is the amount in that account?
Lord, this is a bank statement.
Take that. This is 2022.
Lord, this account has been closed. I'll explain to your lordship, my lord. From 2016 till 2020, the rent amount was received to her.
That I understand.
Please, everything has been marked, my lord.
So
In the
to
last
say
page,
that there is some amount with her today.
please, my lord. This account has been closed. This amount what she was having, my lord, she had opened a new account. In
Where is
that, the amount has been transferred from this account. Last dated 4/1/2022, my lord. Last second page, my lord.
Closed per customer request.
Please, my lord.
Where do you get that she opened another account?
She has transferred the amount which was in this account. She has transferred it to the new account.
Where do you get that?
Last second page, my lord, dated 4/1/2022. Last second page, my lord. ₹3 lakh amount. 4/1/2022, my lord. 14/1, sorry, my lord. 14/1/2022.
It's 14/2.
No, my lord.
14/3. What I see is 32, 33. Then
Lord, 14/1/2022, my lord.
32nd page, you will see 13/3/2022.
On 31st page, my lord.
Huh?
31st page. 31.
But the transactions are there. How do you say that it is transferred?
Lord, this account has been closed.
14/1.
Please, my lord. 14/1/2022. Your lordship may see, my lord, RID for 1 year, so and so number of Miss Shruti K. That's a new account. Lord, when she left the matrimonial home, that is 4/10/1/2022, my lord. Your lordship may see in 31 para. 4/34 was the saving account, my lord. Rather than this, 3.38 of FD plus 1.39 of FD, my lord. Altogether with interest comes to 5 lakh. In July 2022, that amount has been withdrawn by her. So there is no any now what amount, why the amount was used in 2022. She has withdrawn 5 lakh.
You know, she has to sustain from that time. In between, later she came back. In between, they were residing separately.
No, she was residing in her parents' home, my lord.
But she has to spend for herself.
Lord, and even she has paid 65,000 to her brother. It's been evident in 10/1/2022. 65,000 to Mohan.
We will monitor and see. Let him pay 10,000 per month for her expenses. Something, because they are not in good terms. Though you say that
Lord,
both of them
now
are
the
residing
question
together.
is, my lord, I'm paying the
How much
home
is
loan.
earning?
No, I'm not earning, my lord. But I've attended the interview. I'm in hope that I'll get a job, my lord.
Why is not earning?
Lord, in 2022, so in 2025, my lord, I was terminated from the job because my work was low because of this proceedings, my lord. And she had filed a mail saying that I want the entire details of the payment. So there, the employer, you can't do work with these disputes. We are terminating you. Now, my lord is attending your interview now. He's in hope that he'll get a job. Now, my liabilities, my lord, I have to pay home loan, my lord. I don't have any other home. Now, all family have to be taking care of that. Even that I have to consider, my lord. I've taken loan for my education, my daughter's education. I'm paying 15,000 loan to that. In addition, my lord, I've made a FD in my children's account to comply this honorable court's order, my lord. All this.
What is that FD?
Well, this honorable court, before granting stay, my lord, I had to show my bona fide reason, said to make some fixed deposit in favor of the children's, my lord.
How much you?
I have made now 50,000, my lord, in the name of my children's. Lord, now I'm not earning, but I'm in hope that I'll get. It's my hard time. Now, my lord, again paying expenses to wife, my lord. Even I'm taking everything taken care of by me, my lord. Now.
No, who will take care of the day-to-day expenses? She's not earning.
Please,
You're
my lord.
providing her residence. You're
Please.
providing them educational expenses. So with educational expenses, by providing a home,
But even
people will
groceries given by me, my lord. All A to Z
has
expense.
not been given.
I'm getting
Huh?
I'm getting groceries and please order the medicines, ma'am. Medicine, my son's medicine.
The grocery, whether husband is giving.
No, I'm getting the groceries, ma'am. Yes, staying separate, ma'am. There's a partition. I've given the photographs.
He's not giving any groceries. Day-to-day expenses, she'll have to look after herself. She's not giving anything to her.
How much it will be for his medical expenses?
Medical expenses, it's a comes around 8 to 9,000 ma'am per month. Medicine expenses. Now, past 2 years, he hasn't got any medicine. Ask him to show the medicine bill. Ma'am, one more thing.
Well, now she's claiming medical expenses. There is no any doctor prescription, not a doctor is given to take this prescription. She herself wants to give the medical expenses to the child. There is no any particular doctor's prescription saying that the child has to take these tablets. It's according to her own. She says that I want medical expenses.
But it's so unfortunate. The child is just like that, left by both the parents.
Now the reason all this is, my lord, because of your lordships are aware of this, my lord. I don't want to make it again. My lord, everything is transparent to her. Now she's living in her own thoughts. Now she initiated these proceedings. After this, all these issues have come up.
Yes, medical prescriptions. Gangaram Hospital. Documents.
Sir, copy.
So father is not even aware what is happening with the life of the child. Did he take him to the doctor?
Yes, taken, my lord. But these are after the proceedings have been initiated.
This is on 14/3/2022.
After she came out of the matrimony.
All those, the children suffering with those kind of, so they require supplements.
Lord, I'm ready to take care, my lord. My submission is not.
Whatever it is, no, she will not be taking money, and she won't be using it for some other purpose. Whatever medical requirements of the child are there, it has to be taken care of.
Lord, even now I'm ready to take on care of, my lord. But these things, even now she has made an allegation saying that I have not paid for grocery. No, my
Reason why I said,
please, my
no,
lord.
because they are not in good terms. Each and everything, you don't expect her to tell him.
That is the reason it has happened, my lord.
Give it to him. You don't have to pay money. Whatever the doctor has prescribed, get those medicines and give her.
Please, my lord. Please.
Take that copy of that, take a Xerox copy of it and get those medicines. That is fine.
Ma'am, actually, he was studying in LKG, ma'am. After that, he has not admitted him in school, ma'am. The study certificate. Ma'am. Ma'am, even I have sustained a accident, ma'am.
No, the other day I heard you all your problems. I understand. You don't have to tell all
Even
that.
I need to undergo physiotherapy, ma'am. I have two with my leg.
Who has taken care of her medical expenses?
That time.
She met with a big operation. She had a
My lord,
tear and an
after
operation.
2022, she has not said anything to us, my lord. Only with regards to education, he used to ask, what is the education? I need to do it. That's all. Rather than that, there is no any talk between them, even though residing together.
Ma'am, I was staying.
Don't be emotional. Please understand. When was the operation?
Ma'am, October, ma'am. I underwent surgery in
October 2020. What is the surgery you underwent?
ACL reconstruction, ma'am. My both my ACL and meniscal were completely torn out, and there is a rod has been put inside my leg, ma'am. I'm not able to bend my leg. I can't sit on the floor. I can't use the Indian toilet. I need to undergo physiotherapy, ma'am.
Are you undergoing the physiotherapy?
No, ma'am, I don't have money. And the Proceedings, it's a therapy center, ma'am. And for like in 24 hours, he'll be going for just 45 minutes of therapy sufficient for him.
Lord, he says even now there is a medical insurance which is coverable for everybody, but she has not used it. Medical insurance, my lord.
Even if she now gives the bill, he'll get the reimbursement. She's already done.
He is saying at the present, if there is any claim, we can do it, but now it is already done. That is his submission. Lord, all these facts are not brought before me.
No,
now they come before this honorable court and says that I went so many surgeries.
When you, if you claim that you are under the same roof, you are staying, how can he plead ignorance? Because they were staying in the same house. Of course, there's a partition. How can he, if he's really concerned about the family, and if he's claimed that he's been supplying groceries and other things requirement, how can he plead ignorance?
One thing is that definitely your client is not, doing what he is supposed to do. He's not doing justice to his.
Even now there is two kitchens, my lord. One is common kitchen. Now she herself, she has made a kitchen in room and she is cooking everything there, my lord. Now, yes, she has put a grill which your lordships are aware of that. If I go to talk to even my kids, she grabs and she goes in, she locks it. What else I can do, my lord?
So the child is already suffering with autism.
No, that I'll take. I'm not.
What did he do till now? How old is he
My
now?
lord, with the dog,
No, how old is he?
8 of.
Till now, what has been done? What is your difficulty? Why you don't enroll him in that school?
And after my surgery, I was not able to move, ma'am. And after that, he stopped paying the fees. Ma'am, kindly check the certificate, ma'am, study certificate. That's not a school. He's going there for speech therapy and occupational therapy, ma'am. Ma'am, I'm also.
First of all, to send him to any other school, he should be equipped. He should understand.
Yes, ma'am.
For that,
ma'am, I'll
first
show
of
you
all, send him to the school. We will see later. Send him to the school.
Ma'am, he was going to school, ma'am. He was studying in LKG. And he is not admitting him to UKG thinking that it's waste of money. Ma'am, he has studied LKG. He is capable of writing and reading.
Where is that?
Fees which I have paid.
Fees paid, certificate LKG hogi. LKG.
What is the school record of LKG?
Ma'am, TC and study certificate.
Yeah, Magandeya.
No, Magan.
Not that. What was he doing in LKG? Some school record will be there.
Yes, ma'am. Like he knows how to write alphabets. He knows how to write numbers and all. He's capable of reading till 50, and he can say 3-syllable like CAT, cat and all. He's capable of reading and writing, ma'am. I want to put him in a normal school, ma'am. Even
why,
ma'am, he is a.
He's not normal.
Ma'am, DPS, like I'm not stressing on DPS. There are inclusive schools where a special child is allowed to study with the normal kid. See, like he's a visual learner. By looking at them, he'll catch up things easily, ma'am. Now he's 24 hours. He's at home and he's lagging behind, ma'am.
Which is that school apart from DPS?
Ma'am, there are a lot of schools inclusive. That word is called inclusive, ma'am, where a special kid is allowed to study with normal kids, ma'am. That help them.
Have you identified any school?
Ma'am, yes, ma'am. There is DPCure, there is Trio, there is DPS.
Which is nearer to your home?
DPS, ma'am, because my daughter is also studying there, ma'am.
Delhi Public School.
Delhi Public School, ma'am. My daughter is also studying there. Even in her class, there is a child with a hearing impairment.
Hearing impairment is a different aspect.
Ma'am,
that is not. No, you don't have to stick to the DPS.
Okay,
First of all, both of you have not done anything from the last 2 years and keeping the child at home. And now there is a problem with his development. Psychologically, is not as per his age. Now, forgetting about DPS, that and this, first join him in the school and let him go out, let him interact with people, let him learn something. Then after that, next year we can put him in a school where there is inclusive of where both normal kids and the specially able children are also studying.
And that Perseverance is a therapy center where a therapist will be, there'll be one-on-one, ma'am. He won't be interacting with other kids. I'm having the study certificate, and that's not a school, that's a therapy center where a therapist will be giving on one-on-one in like therapy, helping him in just speech and the speech and
So you tell what is the school there he'll join?
Ma'am, I give, Trio is there and Divya is there.
Which is near to your house? That's what I asked you.
Trio is closer by, ma'am.
Huh?
Trio.
Trio is closer by.
Yes, ma'am.
So why don't you put him in the school?
Lord, now this.
He doesn't speak and he doesn't understand. If you put into that school, again he will get in difficulty. difficult time, they will not able to that. That's why we give the assurance to.
Anyhow, you were okay. The boy is at home from the last 2 years.
No, ma'am, I am okay.
Then no, both of you were okay. For whatever reason, both of you have no right to keep him at home like that.
Lord, I've filed a memo saying, even I've requested through our email saying that 6 months it has not been going, please send him to preservation school, my lord.
I have paid the school fees also in the last quarter, but she did not take anything to the school.
I think some order has to be passed that the boy has to be taken away from both of you and be joined somewhere else. Because both of you are failing in your responsibility in the process of fighting with each other. And first of all, you don't send him anywhere and you fight on which school to be sent, either that or this. And so unfortunate that the boy, with all the problems he's having, he's kept at home. And you both of you partition the house, do all kind of things which are not supposed to be done. And always, crying on something, problem will not be solved. You have to do some things which are in the interest. Now I'll be passing an order about his school, about the amounts that has to be paid, and also you also should go to the mediation center, the Bangalore mediation center. There the psychiatrist will be available. You take the boy. You also go. You have to take sessions there in the mediation center, and they will place a report before me after some time. You require that. Please come. How much is going to pay?
Lord, may I request for 5,000, my lord, per month now? I have.
What about her medical needs? What about her physiotherapy? Is physiotherapy required or not required?
But he says even I can claim insurance now if she's going. So we'll give the insurance claim, my lord. Even now, if she's going for physiotherapy, that can be covered under the insurance. Even that is going to provide. He said he'll
Do
provide.
something. You pay first. You have it is a reimbursement, is it not? First she has to pay. Get it.
This has to be paid. I mean, it has to be submitted to the hospital, not.
At present, my lord, now she says she'll go to physiotherapy. So now if she gives the insurance copy, that can be simultaneously that can be claimed. It's not the reimbursement. So he's ready to give the.
Let them give the insurance card so that she can make use of it. Whatever insurance card she is having, if he gives to her, she can make use of it.
On on 28/20/25, this court has passed an order directing the parties to be present before the court in the chambers at 5 p.m. This court had interacted with both the wife and husband, and the children, daughter and a son. The daughter is studying PUC.
Please, my lord. Please.
Studying PUC, and the son is suffering with autism. Who is aged about 8.5 years. Both the parties have their own problems and allegations against each other. But the fact remains is that both of them, for various reasons stated by them, and they have not taken care of the child as required. As he's a specially able child, he requires more attention, and particularly medical attention. But the same is not provided to him. When the court has seen the boy, he is finding it even difficult to have a eye-to-eye contact. Mother, with all the problems or the disputes both the wife and husband are having, she also is in a complete emotional state of mind where that will also add to his add to the difficulties in his development. Both the mother and father over responsibility towards the kid, the parents over responsibility towards the children, particularly a child who is differently abled. It is the case of the father that is taken care of as they're staying in the house. He's paying the he's paying the educational expenses of the daughter, and also groceries and other things he's bringing. According to the husband, he wants to join him in a school that is perseverance, where it is good for the child's development. According to the mother, in that school only there will be a counselor, a one-to-one. There will be a therapist one-to-one, and the boy will not be interacting with. There will not be any interaction with the boy. She submits that there are schools where both the normal and the challenge and the differently able children are also studying. Those kind of schools will make a difference in his development, and he'll be able to cope up and learn things in a better way, looking at the children who are normal. It is also submitted by the counsel appearing for the wife that she has undergone because of a ligament tear. She has undergone operation, and she has to take physiotherapy, but as she is not in a position to bear the expenses, medical expenses, she is not even going for the physiotherapy. Considering all these aspects and more in the interest of the child, this court is passing the following order. The child, the boy, what is his name?
Prasid.
The boy, who is aged 8.5 years, shall be immediately joined in a school where there is a facility for the differently able child and also the normal child. It should be the responsibility of the mother and the father to join the child in the school uh, within 1 month from the date of this order. After joining the boy in the school, he should be reported to this court. Number two, the mother, it is submitted that the father he has paid the insurance, and the wife shall give the husband shall give the particulars to the wife, and also facilitating the wife to undergo physiotherapy. Number three, the wife shall appear before the mediation center on along with the child on 9th of September, and and the 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 psychiatrist counselor shall interact with her, and if required, the counseling session shall be given, and a report shall be placed before the court with regard to her state of mind. Next, the husband shall. Why should there fixed deposit when they are not able to have the basic day-to-day needs? What will the fixed deposit will do?
That was the court's order, my lord, to
So we will modify that order. Let him take the money and pay.
pays, my lord.
Let them take the fixed deposit and pay it every month 10,000.
But may I request 5,000, my lord? Now, my lord,
No, for example, she has to take the child to the school. She has to go to the mediation center. She has to go for counseling or some other things. How much, like even transport itself, how much it costs?
please.
The order dated so and so is modified, and the amount in fixed deposit can be withdrawn by the husband, and every month he shall be paying 1,000 to the, or 10,000 to the wife by 5th of every succeeding month, basing on, and how much time he requires to join the boy in the school.
1 month, my lord. Meanwhile, we'll look after the,
Within 1 month, if the boy is not joined in a school and the same is not reported, and the same is not reported to this court, the court has to take coercive steps. This is matter on 8th of October.
Miller, 10,000 would be too meager an amount to meet your lordship.
We'll see.
but may I request access to my child, my lord?
Happen this way.
Lord,
Please understand.
but may I request to get access to my child, even when I go to speak?
Why you don't give him access?
Ma'am, actually we had been to Enhancement, ma'am, because he heard,
I asked you why you are not giving access to the child.
ma'am, there, because he hurts him, ma'am, he treats him like.
Whenever the mother is on the day the mother appears before the mediation center, she should take the boy, and before the counselor, the father can exercise the visitation. We will see initially.
So the access for both the kids, my lord, not only for my.
But she goes to school.
No, when they're sitting together, my lord, when my daughter comes from the school, she takes her to the room and she'll lock it.
Everything will not happen in one order and one go. Let's see.
He could have interacted when both children were here, but he has not done that.
Yes. And any violation from any of you, both of them have to face the consequences. That I'm making it very, very clear. Everything has to be implemented as per the order.
But
And
even
you
with
should,
regards to school,
you should keep the house where people can stay, not with all the curtains and with all that environment. Come out of, you have to take care of the child who is not well. You have to be all right first. Yes.
Cell number 14, Sushmita K for petitioner.
Petition. Praise time, Lordship. 20, there is a case. Praise time in this case, Lordship. 20, there is a related matter in Davangere. If the matter got settled there, I'll file with it.
At the request of, it is submitted that a mediation is going on in Davangere. This is a matter on 17th of October.
Much obliged.
Yes, next.
15-16 adjourned. Cell number 17, final hearing. Nanjundar Swami N for petitioner. Nandish Gowda for respondent.
Short accommodation.
Why?
I will file the translation copy of judgment. Judgment in Kannada language.
This is matter in the month of January. Some get. Don't give a date. Just list this matter in the month of January.
Jan 2000.
At the request of the counsel for the petitioner.
I apologize, Lordship. Serial number 14, interim order may be
Look at
extended.
it, interim order will send.
Much obliged.
Yes.
Cell number 18.
For petitioner, my lord.
Give that.
My lord, matter has been on submission for the respondent wife. My humble submission is matter has been admitted. I could not get the entire papers, my lord. A short accommodation may I request the honorable court.
What papers are required?
All the exhibits or other documents.
Not required.
Please.
We will not go into any of it.
Very well.
Yes.
Sorry, my lord.
Yes, please look at the impugn order.
Please.
Where is it?
My lord, page number 7. It's
Page number?
7. The papers supplied to me.
Page number 8, ma'am.
8.
The respondent is directed to pay.
Please.
Rupees 7,500 per month to petitioner. Yes. What is wrong with this order?
My lords, first thing is, my lords, the respondent is diploma holder in electronic engineering, my lords. And second thing is, my lords, the respondent
Any
has
children in the wedlock?
no, my lords.
No, ma'am.
No children, my lords. The marriage took place in the year 2003, my lords. From 2005, she has deserted the petitioner. She is living.
2005.
Yes, my lords. 2005. On the same ground, the divorce has been granted by the trial court.
Now, after I obtained the divorce, she has filed this case to get back at me in such a way that. And
No,
my
the
lords,
divorce
she
is
has,
granted.
yes, my lords, on the ground of desertion. Apart from this,
For divorce, no permanent alimony is granted.
no, my lords.
No.
That divorce decree is also not challenged by.
Not challenged, my lords. And she owns a site. She has an ancestral property. All this was not considered, my lords. And moreover, my lords.
Why there is no scope for settlement, Mr. Counsel?
My lord, that I have to get the.
Because divorce is granted.
Yes.
Some
My lord,
amount,
I understand. Yes.
Where do the parties stay?
My lord, my client is in Mysore. My lord, I will contact my client. Today she has.
Let them appear before the mediation center at Mysore.
My lord, before that, my anxious submission is whether there was any settlement talks in the family court, I don't know, because I could not get
No,
any.
any of the mediation drive is going on.
Yes,
Let
yes.
them appear before the mediation center.
My lord,
If it is-
my lord, if one submission is here itself, a date may be given.
Here
Here.
itself only-
Yes, yes, my lord. My lord, I will get my client.
Not here, Mysore,
Yeah.
in the mediation center.
My lords,
But he has to go from Bangalore.
Bangalore.
Let him go.
Let it be. My lords, he's 60 years old, my lords. The petitioner is 60-year-old, my lords.
Both the parties shall appear before the mediation center on 22nd September.
Please, my lord. We will get them here itself, my lord.
Bangalore Mediation Center.
Please.
Yes, next.
10 number, which number?
It is not in that case, but before case, the time.
Much obliged.
Yes, next.
Which number 3? 10 number 1, parted matter. Ayush Agarwal.
Lodge, I appeal
Ayush
for the,
Agarwal for appellant.
Lodge, I appeal for the appellant.
R. Govind.
Your Lodge, we have filed this matter for enhancement of the compensation that was awarded by the trial court in the motor accidents case, Your Lords.
Come to the table.
Your Lords, in this, the appellant was riding a two-wheeler, Your Lords, and when she was riding a two-wheeler, there is.
What the liability is on the insurance company.
Yes, Your Lords.
So we don't have to go into that.
No, Your Lords.
So you are on enhancement of compensation.
Your Lords.
Come to paragraph number 7. So where is the judgment? Come to the table.
Yes, Your Lords.
Where is the table?
Your Lords, table is at page number 8, paragraph number 7. This is the compensation that has been awarded by the trial court, Your Lords.
So you are seeking enhancement.
Yes, Your Lords. Your Lords, the trial court
No,
has.
I do not find the table. Paragraph number
7.
No.
At page number 8 of the.
I'm looking at the award. In the award, there is no table.
No, Your Lords,
they have
there's
not
no.
given any schedule like that.
There's no table, Your Lords, in the award. But Your Lords, we have made a table in our petition, which is produced at page number 8, paragraph number 7.
So what are the injuries?
Your Lords, the injury is that she suffered 28.81% of permanent
First of
disability.
all, for the pain and suffering, I'm asking you what are the injuries as per the wound certificate?
Yes, Your Lords. She had suffered a head injury, Your Lords.
Where do you find that?
Your Lords, the head injury can be made out from the disability certificate, the wound certificate which is produced as Exhibit P3, and the disability certificate which has been produced as Exhibit P6. And also the doctor was.
Come to the order. Please read where it is. All that are not necessary. I just wanted to know what are the injuries.
Your Lordship may kindly refer to paragraph 11 and 12 of the order.
11 and
11, Your Lords. Dr. Vinod Kumar has been examined regarding the disability suffered by the petitioner. According to this doctor, he treated the petitioner on the background of the accident and head injury on 26/10/2015. According to him, conservative treatment was given for about 3 days. He was there and was discharged on 29/10/2015. He was treated in the neurosurgeon department. According to the doctor, the petitioner had the complaint of headache and inability to concentrate. The petitioner was examined by him and the patient was referred for neuropsychological assessment. The doctor has produced a medical file, the CT scan.
How much the court has considered the disability?
Because the court has considered only 10%, your lords. The doctor has already given us a evaluation of 28.81%, your lords. And the doctor has been cross-examined also.
Then what is, income is taken at?
Your lords, the actual income is 15,000, but the court has only taken 8,000 as the income.
Which year is the accident?
2015.
2015.
The court should have taken 9,000 rupees, your lordship. And regarding disability, the tribunal has given a very detailed return because the complaint he was referring to was that he has got loss of memory, he is not able to concentrate and all. The doctor who has treated was not the person who assessed the disability. Another doctor from the physiological department has given a report based on that the doctor has given a disability, and the tribunal finds that the disability assessment is very much on the higher side. The doctors who has actually assessed the
So cross-examine the doctor, what could be, what you have elicited from his cross-examination to, not to.
In cross-examination, he says that he has not personally assessed the disability. I am giving this report based on the report given by the neurophysiological department. And the tribunal, in the cross-examination also, he said that, Your Lordship may kindly see page 9, paragraph 11. In cross-examination also, almost middle of the page. In the cross-examination also, he said that he remembers, this is the cross-examination of the PW1, that is the petitioner. He categorically states that he was discharged within 2 days from the date of treatment, no surgery was conducted. If we consider the answers of PW1 during the cross-examination, evidence given by way of affidavit in lieu of the chief examination, the disability stated by PW2 appears to be an exaggeration. Moreover,
15%.
Your lords, my only submission is that the doctor has already said 28%. The trial court has held it at 10.
The treated doctor, he has not assessed the disability.
Lords, but he has looked at the medical report given, and then he has given his expert opinion. I can read the cross-examination.
He has to examine the patient and give the assess the disability, not looking at some records.
Your lords, my only submission is that the trial court judge has held that disability is 10% because the petitioner was answering the questions correctly during cross-examination. Just because
what is the multiplier?
Multiplier is 18. Your Lordship, the income can be taken at 9,000 rupees because that is the LSA schedule. This one, 10% disability is taken. There will be an additional compensation of 22,400 rupees towards.
We'll take 15% as result. 91,600. Then how many days?
Then it will be nearly 33,000 rupees. Will be.
How many days he was in hospital?
3 days.
2 days in the hospital.
3 days, your lords.
Including the date of admission. From 26/10 to 29/10. 3 days.
What are this? Conveyance 5,000, 10,000, right?
The Lordship may kindly see there is a
charges 3,000.
Pain and suffering of 50,000 is.
1 minute. What are these for 3 days hospitalization? On what basis court has granted 10 plus 5, 15 plus 3, 18,000 is granted?
Your lords, she had to go to the hospital multiple times for checkup, your lords, because she did for about.
What is the discussion letter see while granting?
No evidence tendered.
Just like that court can't grant. There is the attendant.
And tribunal has granted 10,000 rupees towards diet.
You know,
and 50,000 rupees for pain and suffering for a head injury which is treated conventionally. So when you compare, find these awards, the other award, it appears to be not only reasonable, slightly on the higher side. Of course, insurance company has not taken the matter in appeal. Regarding the disability, my submission will be the percentage of disability calculated by the tribunal may be taken, and the income may be increased to 9,000 from 8,000 because that is the.
The tribunal has taken 10% on the ground that he was answering questions during cross-examination, your lords, which is contradictory to the evidence which has been placed on record.
Because actually he was
There's a
assessed-
medical
the disability
certificate.
was assessed by two doctors by name Priyanka and Indu. This is also common evidence. There was no difficulty in examining either of these doctors to say whether there is.
It's 2015 is when the when the accident happened. The cross examination took place in 2020.
That's how it happens.
Yes, your lords, but my only
Uh,
submission is that
Now we will take 15% as.
Maybe 12%, your lordship, because he doesn't have, when I go through the medical records, I don't find that he has got that much disability. And the tribunal also has personally seen the.
your lords, the tribunal has
It may be
not
ta-
medically
and-
examined the.
Let him complete. There are certain fixed
He-
norms
he-
for
your-
motor vehicle accidents to grant compensation.
If it is taken 15% also, it will come to nearly 33,000 rupees enhancement. In the Lok Adalat, we offered that amount also, they did not agree.
It's coming to 3,16,280.
In the place of,
Your lords, loss of income, they've only calculated for a period of 2 months, your lords.
That is not added, that I'll add. Loss of income during later period.
Yes, your lords.
your lordship may kindly see for diet 10,000. On other heads, exorbitant awards are given.
No,
So
just diet
it may
and
be,
medical.
I have already reduced all that.
yes, your lordship, I didn't,
I've reduced all that.
yes, your lordship.
Diet and it's.
That can't be granted like that. That's not how it is calculated. 27,000. It comes to 3,43,280. Please come.
So there will be an enhancement around 60,000 rupees. 288 is the lower court award. In fact, I have suggested in the Lok Adalat that they could have compromised.
That's why judicial order.
Eh?
That's why judicial order. Agreed with award passed in embassy number 375 of 2016 dated 25th February 2021, whereby the tribunal had awarded compensation of rupees 2,88,700. The claimant is before this court seeking enhancement of the compensation. The claim petition is filed seeking compensation of an amount of how much? 20 lakhs for the injuries sustained by the claimant. It's a case of the claimant that she has sustained head injury, was treated conservatively while in the hospital for 3 days. 3 days. And the court taking the income at 8,000. And as the evidence of the doctor is that the claimant had sustained 28.8% disability. And the court had taken 10% as disability and granted the compensation as per the table given below. Look at it at page 8. It is not along with that's why I've folded this. Then counsel appearing for the petitioner submits that when he has sustained the head injury, the compensation that is awarded on all the heads is not just unreasonable. It is submitted that the court ought to have taken 15,000 as income. Further, when the evidence of the doctor is that he has sustained 28% disability, court had taken 10% without any basis. Even in the cross-examination also, they could not elicit anything. Even under the head of loss of income during the lead-up period, the amount that is awarded by the tribunal is on the lower side. It is submitted that on all counts, there needs to be enhancement. Then counsel appearing for the respondent insurance company submits that the petitioner was, the appellant claimant was treated conservatively. The doctor who had deposed, who has given evidence is not the treated doctor. And he has not even in the
One small correction.
cross-examination.
It is not that he is not the treated doctor. He was in the hospital. The assessment is made by two different doctors.
The doctor, the assessment is made by two different doctors. and they have not physically examined the climate. It is submitted that on all the counts, the tribunal had awarded the higher compensation. Under the head of attendant loss of attendant charges, the court had granted conveyance 5,000, attendant and nourishment 10,000, diet and nourishment 10,000, attendant charges 3,000, and towards amenities 25,000. All are on the higher side. Next para, having heard the counsels on either side, there was a material on record. Considering this court, though there is no appeal filed by the insurance company, while computing the compensation, if the amount is excessively awarded, the court can as well interfere with the same towards the pain and suffering for the head injury, which is conservatively treated. Court had granted 50,000, and this court is making it as 40,000. Towards attendant, nourishment, and conveyance, he was there in the hospital for 3 days. This court is granting 3,000 rupees. Coming to the permanent disability, the learned counsel appearing for the respondent had rightly argued that the doctor, without any basis, has assessed the disability, and but the court had taken 10% in the facts and circumstances. This court is inclined to take 12%, and the income at 9,000 as per the chart, as this accident had taken place in the year 2015. 9,000 into 12 into 18 into 12 by 100 is 2,33,280. Towards loss of amenities, the trial court has awarded 25,000, and this court is granting 30,000. In the towards loss of income during the later period for 3 months, this court is granting 27,000. In the light of the law laid down in Mekala versus so and so, towards legal expenses 10,000. Altogether, the claimant is entitled for an amount of rupees 3,43,280. Accordingly, appeal is partly allowed, enhancing the compensation from 2,88,700 to 3,43,280.
Lordship, it's a question of pay and recovery.
Enhanced amount shall carry 6%. That's order of the
Pay and recovery is the order.
as per the tribunal has already passed an order of pay and recover. Insurance company shall pay and recover. Yes, next.
Cell number 2 for dismissal matters.
Acha, please.
We'll pass order.
PC
You are right.
Shivanagowda.
That you can argue. Yes.
Insured himself was claiming the compensation for his own negligence.
Let's see that.
Please.
Where is the finding?
I will. Yes. But para 11,
This is filed under 163A.
please.
Yesterday, somebody was arguing, Mr. Shashidhara or somebody.
Correct, madam. What has happened, madam?
He's relying on some judgment.
Ram Kiladi judgment. That
No,
was
he is
also-
not relying on Ram Kladi. He is relying on some judgment of Justice Sudhanshu Dhulia, which is where the matter is referred to the full bench. And he is saying that under 163A, even fault is yours, still you can maintain a petition.
No, in this case, my lord, he is the owner of the vehicle. He himself is the owner. He cannot maintain the claim petition. If the third person was riding the motorcycle, my lord,
Oh, he
can
is the owner of the vehicle.
He is the owner of the vehicle, and we have paid the PA claim also.
Oh, PA claim is also filed.
PA claim is also, therefore, he is not, whatever the amount eligible.
See, which from
But
where?
what they say, my lord, as per the amended act, under 163A, 5 lakh will be the compensation that has to be. But the accident is prior to the amendment. Therefore, that provision, it is a prospective in nature, it is not a.
What is amended provision?
The amendment, 163 petition was amended. Now, the compensation is enhanced to 5 lakh.
This,
That for that matter, he is not entitled to get. That's what the court has
Come
observed.
to page, internal page 25, middle of the page. The Honorable Supreme Court held that the claim petition under section 163A.
20,
Internal page 25. Middle of the page.
para.
Well, there's only one para. 25, it's continuation of paragraph number 15.
Please.
Honorable Supreme Court held that
the honorable attention, the latest judgment of honorable Supreme Court was passed. Correct, Mila?
next page on the right side.
Thus the said claim petition came to be allowed partly in direction the insurance company to pay the compensation. Feeling reviewed by the award of insurance company filed the appeal before the Honorable High Court. Honorable High Court allowed the appeal and set aside the judgment. Award passed by the tribunal. Consequently, dismissed the claim petition. Feeling aggrieved by the dissatisfied with the judgment of order passed by the Honorable Court, the original claimant have filed the appeal before the Supreme Court. The Honorable Supreme Court held that claim petition under 163A is based on the principles of no part liability. However, the same is deceased has to be a third party and not maintain a claim under 163 of the Act by the owner or the insurer of the vehicle is borrowed from him, as well as the basis of the he is step into the shoe.
I think we will come to para 16.
60. So I'm going to the clear decision which is cited supro. Section 163 of Motor Vehicle Act filed by the petition is not made. Though learned counsel by the petitioner has not only addressed the argument on the instead of application, but also addressed the argument amended provision 2019. But when the deceased himself was the rider come owner of the accident was occurred in the year 2016, claim petition is not only maintainable but also entitled to compensation of the amended act. In one of the provisions cited supra, therefore the argument of advance by the learned counsel of the petition aspect holds no water. That's what Malad court has said. The learned counsel by the respondent canvass the argument submitted.
Court has recorded about that the personal accident coverage is already paid.
It is.
Where is it?
2 lakh it was granted.
No, is it recorded in the order?
It is recorded. Please. Para 11 in page of judgment 19 minute. Thus, the High Court accepted the contention of, however, directed to pay the 2 lakh for the personal accident component so. Since the indemnity is extended to the personal accident.
Paragraph number 19 is not that.
No. Page number 19. La?
Internal page 19. To pay
that was deducted and we made the payment also.
No, it is not pertaining to your case.
But no, this is discussed in
pertaining to a
page number 16, page number, para number 16, para 15 indemnity. 2009. The petitioner, the respondent has already paid rupees 1 lakh to the elders of the deceased. Para 15 end. In page number 26 of the tribunal award.
Admittedly, as per the argument which advanced with the consular, has already paid rupees 1 lakh to the LR. So that is right? Yes. Please come. The present appeal is filed. Agreed with the dismissal of MVC number 1749 of 2017 dated 29 July 2020. The claim petition is filed under section 163A of the Motor Vehicles Act. It is a case that accident or taken place on 15/8/2016. The deceased with the owner cum rider of the motorcycle as and of the date of the accident. And the accident is occurred due to rash and negligent riding of the deceased himself. And the jurisdictional police have filed the charge sheet against the deceased in crime number 282 of 2016, for which the the court by order reviewed had dismissed the claim petition on the ground that as he is the owner of the vehicle, even under 163A, he is not entitled for compensation. He is entitled for the personal accident coverage. An amount of rupees 1 lakh is already paid by the insurance company and accordingly dismissed the petition. This matter on 4/1/2024. Five six 2025, 3/7/2025, and there was no representation. On 22/8/2025, also, as there was no representation, this court had directed the matter to be listed under the caption dismissal. And also, the order reveals that no further adjournment shall be granted for the matters which are listed under the caption dismissal. Today, when the matter came up, there is no representation on behalf of the appellant. It appears that the appellant is not interested to pursue the matter. Next one. Then counsel appearing for the respondent insurance company submits that court has rightly considered and held that the claim under 163A is not maintainable as he is the owner of the vehicle and under already compensation under the personal accident coverage is already paid to the LRs of the deceased. Having heard the counsel for the respondent, there is the material on record. The present application is filed under 163A of the Motor Vehicles Act. The deceased is the owner cum driver of the vehicle. The under 163A, even for the no fault liability, the owner of the vehicle is not entitled to file an application under 163A, 163A, as as it is even as per the insurance policy, it is the claims of the third party are covered with the same. At best, the owner of the vehicle is entitled for the personal accident coverage and already as submitted with the land comes for the insurance company, an amount of ₹1 lakh is already paid. In those circumstances, the court had rightly held that the claim petition is not maintainable. In those circumstances, this court do not find any reasons to interfere. Accordingly, appeal is dismissed. Next.
Number 3. Tejas Reddy.
Appeal to the appellant, madam, because the needful has been done.
Ish Kumar.
Do that.
Sure.
Who is R3?
Madam, the insurance company.
Which is the insurance company?
Madam, the New India Insurance Company Private Limited.
Who appears? New India Insurance Company. Assurance Company. The appear is Janardhan Reddy. New India Assurance. Mr. Janardhan Reddy is directed to take notice on behalf of the insurance company. Delete from the caption dismissal. Land counsel for the appellant shall serve the copy of the appeal memo on the counsel. List this matter on 16 September. Serve him today itself.
Yes.
Yes, next.
Still number 4. Manjuna Kendi.
Yes.
4 Manjuna Kendi for appellant.
The present appeal is filed seeking enhancement of the compensation. This matter came up on 1/9/2025. As there was no representation, the matter was listed today under the caption for dismissal. Today also there is no representation. Accordingly, dismissed for non-prosecution.
Still number 5.
Yes.
Chantraj.
Serial.
My matter, advocate.
Serial number.
The serial number 5.
I appear in serial number 2, ma'am, third list.
It's already over. The on 16/7/2025, as there was no representation on 6/6, initially there was no representation on 6/6/2025, and the matter was directly listed on 16/7. Again on 16/7/2025, there is no representation, and the matter was directed to be listed on 2/9/2025. This is an appeal of 2023. Even till now, the process is not paid for issuance of notice to R1 and R2 for the first time. In spite of an order dated 14/2/2023 and 6/6/2023, it appears that the appellant is not interested to pursue the matter. Accordingly dismissed.
Serial number 6.
Serial number 6, I appear for the appellant, my lord.
Yes.
My lord, this is a dismissal of claim petition filed by mother, wife and children on the ground that there is a delay of 6 days in filing the complaint. That is only reason,
Let's see.
my lord.
Where is the counsel for the insurance company?
Tejaswini is
Tejasvi.
Heard the learned counsel for the appellant in part. No representation for the insurance company. List this matter day after tomorrow. Even if there is no representation, the matter will be disposed of on the merits of it.
Serial
Seven.
number 7.
much about.
Mantel Bharadwaj. Serial number 7.
Just for dismissal on Tuesday.
Serial number 8.
Memo is filed seeking dispensation of notice to R1. Dismissed with number 1 of 23. Tata AG General Insurance, who appears?
Tata AAG.
You appear. So Mr. Janardhan Reddy is directed to take notice on behalf of Tata AG General Insurance, respondent number 2, and the land counsel for the appellant shall serve the copy of the appeal memo. I number 1 of 23 is filed to condone the delay of 133 days. For the reason stated, delay is condoned on condition that he will not be entitled for interest. Next, 9.
8. HV Manjunath.
9 is not SV Manjunath, it is.
8 is
yes.
serial number 9.
Yes, yes.
Appeal for appeal, my lord.
Manjunath.
PF is pale, my lord. I need to serve the copy to R4.
Who is R3?
My lord.
Who is R3?
R3.
Notice has to go to R3.
For second time.
Lord, I need to serve the copy for R4. my lord.
R4 is A.N. Krishnaswamy. Have you served?
No, my lord. I need to serve. Is
No, liability. Who is R3? R3 is. There is no R3 in this. Only 2 respondents.
my lord, there are 3 connected, my lord. 2148, my lord. MF.
I am looking at MFA 2. Anita, you've given 655. What is this? Is the owner of the vehicle?
There are 3 appeals. 3 appeals. 9.1, 9.2.
No, the liability is on the insurance company.
Yes, ma'am.
And then who is he? Who is the third respondent? Look at it. This is matter day after tomorrow. If the liability is on the owner, you can file a memo seeking dispensation. Yes.
Cell number 10. Cell number 10, Vasant Kumar.
Appellant just paid process to issue notice to respond number 1, who is the claimant, who is appellant in the connected case. I think there is a direction by this court to the advocate who represented the claimant in the connected matter. They have failed to file a,
The Hegde
please,
is for the claimant.
please.
He's
In a-
already here in 10 also.
He has not filed wakalat in this matter, 4185. That's why this court ordered for pay process.
Why again notice to R1? Where is he?
Connected
That's what
matter.
I'm saying. Why notice again?
Alla,
Waste
there is
of
a
time.
direction. He is not filed wakalat. That's why court ordered to pay process. There is
Because
observation.
both are connected. His presence is there.
Just have paid process. That's the reason. Kindly see this. He has not filed wakalat for that.
No process is required.
I've already paid.
Admit post for final hearing.
Public. Interim order.
Connected matter is
There
already.
is interim order of stay of execution.
Interim order earlier granted is
Please.
extended. Yes, 11.
Cell number 11. Cell number 11, Girish B. Baldare. Non-filing of translated.
What is this non translated copy? Huh?
Claim person itself has been dismissed by the tribunal.
Heard the learned counsel for the respondent, no representation for the appellant. List this matter for dismissal on Wednesday, coming, not this Wednesday, coming Wednesday. Yes, 12.
And cell number 12. Cell number 12, KP Bhuvan.
Respondent.
D. V. Venkatesh.
There is a delay in 343 days, my lordship. After filing of my earlier claim, that is owner appeal, then only prepared this present petition regarding enhancement.
Who are you? You are the owner of the vehicle.
Yes, my lordship.
Next appeal is claimant's appeal.
That is,
First one is claimant.
Huh? First is claimant's appeal.
first one is claimant's appeal.
Second is owner's appeal.
Owners,
Liability is on owner.
yes.
On what ground?
On that is, there is a delay in filing complaint and contributory negligence also there. These
No,
points.
I'm asking why is the liability fixed on the owner of the vehicle?
Owner, the insurance not there. That's
No
why.
insurance.
Tractor, that is.
So let's see the order.
3,78,161. Only 2 injuries, my lordship.
Let's see the table.
Table
So
is
only on the quantum.
quantum, that is disability 30,000. Injury is, injury number 2 is grievous, so, and 1 is simple in nature.
Pain and suffering 30,000.
Yes.
Treatment expenses 28,000. Loss
Medical,
of earning capacity 3 lakhs. Food, nourishment and attendant charges 20,000.
this one only the admitted in government hospital, the claimant. That is in Tumkur government hospital.
Now why 3 lakhs is granted? The doctor was examined.
Doctor, that is
Because the disability according to him
40% of disability, madam.
to the limb.
Injury number 2 is 40% disability.
To the limb. How much
not
quoted
limb,
comes?
neck.
Injury number 1 is 50% disability.
See, that is only delay, and my submission is only the patient as, claimant has been admitted on date of accident 1718, my lordship. And complaint lodged on 7718 and discharged on, as per the exhibit P7, discharge summary 19/7/2018, my lord.
We'll hear it some other day.
19 days.
This is matter on 8th
And
of,
delay is concerned regarding enhancement claim petition is, that
8th,
is,
8th of October. We'll see. Yes. Next.
Cell number 13. 13 adjourned. Cell number 14
My lord, serial number 13 appearing for response.
is adjourned.
Morning, somebody has asked for adjournment. Yes. 14.
Cell number 14, H.C. Rushbendraya. Latur,
No representation. This is matter in the month of January.
he is there.
Where is the respondent?
He also filed an appeal, my lord. I have filed appeal on the question of
He is not to be seen.
Yes. Lord,
So Suresh Lathur.
today I have not seen.
So before also, I have not seen the smart learn counsel for the insurance company is present. No representation on behalf of the claimant. This is matter in the month of January.
Next week, my lord.
He'll not come unnecessarily one matter in the list.
Cell number 15. 15, Prithvi Vadeya, or petitioner.
The petitioners herein were respondents number 3 in the MFA, your lordships. And they were defendants number 3, 4, 5 before the trial court.
Where is the order?
Order sheet I too have produced and your lordships are secured at page 25. No notice was ordered on these three.
That's passed on 5th September
5/9/2025. And your lordships kindly turn. The caveat was filed by defendant number 1 alone.
Who are you?
I am defendant number 3 to 5 before the trial court.
Defendant means what are you? It's an MFA of
MFA.
so not under Motor Vehicles Act.
No, not under Motor Vehicles Act, CPC.
You are the defendant number?
3 to 5 before the trial
So
court.
what is the suit for?
Suit for declaration and possession.
Oh.
Plaintiff filed 2 IS before the trial court. IN number 10 for not to put up construction. IN number 11 not to alienate the property. Though both the IS came to be rejected by the trial court, against which the plaintiff approached this honorable court in MFA. The defendant number 1 alone had filed caveat.
How are you related? How the defendants are?
Defendant number 1 and 2 claims to be the owner of the property. 3 has entered a joint development agreement with defendant number 2 for putting up construction of flats. And I had, by the time the suit was filed, I had constructed and 9 flats were constructed.
Take notice. Yes, notice.
Serial numbers. For
Take out
admission
hand
matters.
summons on the council. Petition is permitted to take out hand summons on the council appearing before the trial court for the other respondents. Yes.
Serial numbers. For admission matters, serial number 16.
For enhancement of compensation.
Where is Pradeep? So again, I should issue notice. Complaint of
Though I have not
Pradeep.
received the copies, my lord, friend has not served.
Give him papers.
Will give.
Land counsel for the appellant shall serve the copy of the appeal memo on the council appearing for the insurance company. List this matter on 24th.
Copy served, my lord.
Serial number
Acknowledgement is there.
18. Acknowledgement.
Anyone is asking, serve it, we will hear it. Yes, 17.
Date may be.
17.
Yes, date is given.
BP Radha.
Please. This case I have for the response. KSRTC has challenging negligence.
Negligence. Where is
Radha,
BP Radha.
Radha?
claimant has filed the appeal for seeking enhancement.
No representation on behalf of both the appellants. List the matter in the month of January.
Serial number 18. Serial number 18. FS Dabali.
Yes. Claimant and corporation.
Serial number 18.
Yes.
Harish Annar.
You are on what ground?
On the point of negligence, not we have filed this appeal.
Only on that point.
Only negligence. Quantum, my lord, it seems reasonable.
According to you, there is contributed negligence.
Contributed negligence.
Where is that discussed? Audition.
Para 16, my lord. What case is not the claimant was riding the scooter, head of the
The paragraph number
para 16, my lord.
16 of the order.
Internal page 10, my lord.
Huh?
Internal page 10 of the type page 10 of the judgment.
Para 10.
Para 16, my lord.
Yes, please read.
taking bird's eye view towards documents revealed that alleged accident had taken place on 2/7/2022. First information in this regard was given on the same day by the wife of the petitioner by name so and so. On the basis of her information, criminal law set in motion against the driver of the offending vehicle, alleging that he had committed the offence punishable under section so and so. There is no delay in giving first information about the accident. In the recital exhibit P1 and P2 and also in the statement of petitioner marked at exhibit P3, there is clear narration. There is clear narration about the negligence said to have committed by the driver of the offending vehicle, which caused the accident as well as injuries to the petitioner. These material documents remain unshaken by the other side. Apart from this, the ongoing through the Mahajar exhibit P3, police intimation exhibit P4, police notice, reply notice, report of the motor vehicle inspector, spot sketch evident that after setting criminal law in motion against the driver of the offending vehicle, the investigation officer visited the scene of occurrence and conducted a spot measure in the presence of the Panchayat. At the time, executed a spot sketch which reveals about the involvement of the offending vehicle in the accident, as well as the negligence on the part of the driver of the offending vehicle. No whisper in the recitals of the spot sketch and spot measure to the effect that due to the negligence on the part of the petitioner, accident and its consequences were taken place.
So, to say that there is contributory negligence on the part of the deceased, what is the evidence?
Yes, ma'am.
What is the evidence?
The evidence but the spot measure, sketch mode and IM report. Exhibit P6 mode. P9 is the spot sketch mode.
What it says?
Where request mode.
But the charge sheet is filed against the driver of your
Charge
bus.
sheet has been filed, but there is no dispute about
The
it.
driver is examined.
Our case is not, he suddenly.
Your driver is examined.
Our driver is examined. Even as per the spot sketch and Mahajar, the spot has been shown at a distance of 3 feet from the eastern edge of the tar road. Our case is not, the accident took place almost in the middle of the road. The claimant who was riding the scooter but suddenly stopped the vehicle, due to which
Both are coming on the opposite direction.
no,
or in
no,
the
same
direction.
direction.
Hmm.
Due to which the accident took place. Even the IM report also shows that
The bus hit the bike from the back.
that is the case of the claimant.
Then how can there be a contributory negligence?
No, our case is not the claimant who was riding the scooter but in front of the bus in the middle of the road. He suddenly stopped the vehicle, but due to which
There is evidence for that. You're only except your driver's evidence, there is nothing.
but as per spots measure, sketch mode and the IM report, which clear,
It will not disclose that he has suddenly stopped the vehicle.
no,
It only shows the position of the
the
vehicle.
spot has been shown at a distance of 3 feet from the left edge of the tar road.
Why your heavy vehicle is going on to the extreme left of the road? Yes, come. What about your enhancement?
Enhancement with regard to
Where is the table?
Please, ma'am. The doctor has assessed disability to 35% to the right lower limb.
Oh, this is a case of injury. What are the injuries?
20% to the whole body doctor has stated.
Injuries, head injury, bilateral nasal bone fracture.
Where do you get that?
Committed fracture.
Where do you get that?
Paragraph.
Mild head injury, bilateral nasal bone fracture, fracture of the left clavicle, multiple rib fractures of the left side, fracture of L1. Oh, how much is granted?
The total compensation of.
Not total, pain and suffering. Come to the table.
Doctor has stated about 20% to the whole body. That
Pain and suffering, how many fractures?
Five.
How many fractures? 1, 2, 3, 4, 5, 6. 6 fractures.
5 grievous injury.
How much is granted? 75. Yes. Next.
Future prospect.
Loss of income during later period, which when is the accident?
Data of accident.
2 and 22 mode. 15,500 has been taken by the tribunal. As per
It should have been
notional income.
2019,
22, madam.
22
Notional income has been taken, 15,500.
is taken. For how many months? It will take
For-
6 months
for-
with all these injuries.
2 months,
So many fractures.
so many fractures, but he was inpatient for about 14 days, not in the hospital.
3,000. Next, medical expenses. Six lakhs, 90,517. How many days was in hospital?
14 days, no.
Will not enhance.
That so far as disability is concerned, madam. Doctor assessed disability to 35% to the lower limb, madam. And other portion of body, madam, whole body it is taken 18% instead of 20%. Whole body disability assessed by the doctor is 20%. Instead of 20%, 18% is taken, madam.
No, what is the limb disability?
Limb disability.
60%.
If I doctor evidence,
9% to the right upper limb and 12% to the right lower limb. Whole body disability, 20%.
Where do you get that?
doctor evidence, madam.
No, from the order.
Internal page 24 murder.
24. Right upper limb, so and so. 35%. So the whole body, 20%.
Whole body 20%. Whole body 20%. Not the trouble has taken 18%.
18%. And income is 15,500.
500 has been taken.
15,500 into 12. What is the multiplier?
7 more. 62 years.
7 into 20.
He was working as a architect murder.
It's coming to 2,60,400. Then loss of amenities reasonably granted.
35,000 has been 35,000 has been awarded.
Yes, mister.
15,000.
35,000 is granted. Loss of amenities.
15,000 may be added. Another 15,000 may be added.
Yes, what do you say? Sidabali.
Yes, ma'am.
He is asking for another 15,000.
Amendment is not reasonable amount, but only parent suffering murder, some amount can be.
Where? Parent suffering already I have enhanced. Is there any evidence of the doctor with regard to future medication?
No, no.
No.
It is coming to 9,53,517. How much is granted?
10,85,000.
No, something is missing.
Medical bills.
It's coming to 12,13,917. Yes, please come. Agreed with award passed in embassy number 4645 of 2012 dated 21st of June 2023, whereby the tribunal has granted compensation of an amount of rupees 10,85,877, 77, both the BMTC,
BMTC.
for the BMTC as well as a claimant or before this court. BMTC is questioning the award on the ground that there is contributory negligence on the part of the claimant, and the claimant is before this court seeking enhancement of the compensation. Next para. Then counsel appearing for the BMTC submits that there is contributory negligence on the part of the claimant. The same is evident from the evidence of the driver who is examined by the BMTC. And further, the IMV report and the spot sketch also supports the case of the appellant BMTC, which clearly, the spot sketch clearly shows that there is contributory negligence on the part of the claimant. When it comes to the compensation, it is submitted that the court had granted compensation which is just and reasonable, and no interference is called for. When counsel appearing for the respondent claimant submits that not respondent, the counsel for the claimant submits that court had rightly considered and held that the accident had taken place because of the rash and negligent driving of the driver of the BMTC bus. In fact, the charge sheet is filed against the driver, and all the police evidence is against the driver of the opposite vehicle, and the court had rightly fastened the liability. When it comes to the compensation, it is submitted that he has sustained as many as 5 previous injuries, and the court has not granted reasonable amount under the head of pain and suffering. Even under the head of loss of income also, court had only considered 2 months. Further, towards loss of amenities, the amount that is awarded is not a reasonable compensation. It is submitted that when the doctor had opined that the disability to the whole body is 20%, the court without any basis had taken the disability at 18%, and the same needs to be enhanced. Next para. Having heard the counsels on either side, there is the material on record. The police, after a full-fledged investigation, has filed the charge sheet against the driver of the BMTC bus. Even this court has perused the spot sketch, IMV report, and none of these documents support the case of the BMTC that the accident there is contributory negligence on behalf of the deceased. In that view of the matter, this court is of the view that the court had rightly held that the accident had happened because of the rash and negligent driving of the driver of the opposite vehicle. Then coming to the compensation, the claimant had sustained
Para 25.
para
25.
claimant had sustained head injury, bilateral nasal bone fracture, left clavicle commuted fracture, multiple rib fracture, right superior and inferior public ramal fracture. And considering all the injuries that are sustained, this court is granting an amount of rupees 90,000 towards pain and suffering. The court had considered 15,500 as income. Considering these many injuries under the head of loss of income during the later period, this court is granting for 6 months 15,500 into 6 is 93,000. Medical expenses and attendant and nourishment and conveyance court had rightly granted, and no interference is called for. Coming to the loss of future income, the doctor has opined that the whole body disability with respect to the right upper of the claimant is 9%, whole body disability with respect to the right lower limb is 12%, and total whole body disability at 20%, and total disability of the right lower limb is at 35%. The court had taken 18%, and there is no basis of the court to take the disability at 18% when there is evidence of the doctor is consistent, and also looking at the injuries that are sustained by the claimant, this court is taking the disability at 20%. 15,500 into 12 into 7 into 20 by 100 is 2,60,400. Considering the injuries and the disability, the head of loss of amenities, this court is granting 50,000. In the light of the law laid down in make law so and so legal expenses 10,000. Altogether, the claimant is entitled for an amount of rupees 12,13,917. Accordingly, the appeal of the claimant is partly allowed, enhancing the compensation from 9,57,517 to 12,13,917. Accordingly, the appeal of the BMTC, that is MFA number so and so, is dismissed, and the appeal of the claimant so and so is partly allowed by enhancing the compensation from
The amount in
9,53,517 to 12,13,917. The amount in deposit shall be forthwith transferred to the court. There is a delay of 130 in 18.1 docket order. There is a delay of 137 days for the reason stated. Delay is condoned on condition that is not entitled for interest for the delayed period. In the operative portion also this. Yes, Nick.
Cell number 9.
Yes.
19. Cell number 19.
There is a respondent, Krishnamurthy MR.
Krishnamurthy MR.
We'll have this list from 19 to end tomorrow.
Please, the records may be called for.
It's there. It is not there. Admit post for final hearing, call for the TCR. All these final hearing matters repeat tomorrow. Look at it. If tomorrow is.
Serial number 21, my lord. My lord, serial number 21.
A complete list on that day. Then. Yes.
My lord, serial number 21.
Hmm.
It may kindly be posted after a week.
Yes, all these matters will come on 8th. That is the day where less matters are there.
Serial number 26. Serial number 26 part addani chain.
26 on 8th.
Serial number 17. It is urgent. Petitioner advocate is on record is here. It will be having tomorrow.
So and so tomorrow. That number.
17.
Yes.
This number 3, 29th man. That when MFA connected 639, before the executing court, the respondent number 1 has paid the amount, and that may be disposed of.
Tomorrow, list that matter. Tomorrow, let them also be there.
29.
29 tomorrow.
Connected matter.
I post along with so and so.
29, it is already
Give the number.
attended in the morning.
But again, list it, no problem. Change that and list it because he says that it's already paid. Yes.
There are two appeals, my lord.
That's what he's saying.
There are two appeals here. In respect of MFA number 639, respondent number 1 has paid the entire amount, and that DHR also filed a memo regarding that, and stating that he is fully satisfied. Yes, that MFA can be disposed of.
We can have it tomorrow and see.
My lord, I will get the instructions, my lord, whether it's correct.
And day after tomorrow. Take that matter and day after tomorrow.
The other matter is that, my lord, I think my learned friend is stating about only one appeal, my lord. A small amount of compensation is available. I have sought for enhancement and fixing the liability on the insurance company, my lord.
Let that come. Let come. I think that's already adjourned. She's saying on 2nd, 2/12. The other matter is adjourned to 2/12.
Both connected.
Connected matter.
Let it come tomorrow. We will see. Tomorrow. Day after tomorrow not
Next week, my lord.
Huh?
Tomorrow I am out of.
Then
this.
8th. Both the matters on 8th.
Sir. We start with the question.